Got it. Okay. Ms. Rivers, good morning. Are you ready to go?
Good morning, Judge. Yes, I'm ready.
Great. We're going to handle our bond hearing with Emmanuel Hinton. This is 23 SC 187752. Good morning, Mr. Hinton.
Good morning.
How are you doing today?
Good.
Good. Today, Mr. Hinton, all we're going to talk about is bond. So Ms. Clark, your lawyer, is going to talk to me about why you either should get a bond or I should lower your bond. I don't know if you have no bond or it's just a number that you and your family cannot afford. So I'll hear from Ms. Clark about that. Then I'm going to hear from Mr. Peoples, the prosecutor handling your case. And I'll let you know before you go what I'm going to do with the bond situation. Okay? Yes?
Yeah.
Great. All right, Ms. Clark, when you're ready. You can be, as long as you all are near microphones, you can be podium, desk, I'm open to, I just need, I can hear you. I need Ms. Rivers to be able to hear you and she will hear you through a microphone.
Thank you, Your Honor. This is a motion to reinstate the bond. Mr. Hinton was out on bond. It looks like the bond on October 28th was 45,000 split bond. And with conditions, obviously, the 24-hour curfew and ankle monitor and being supervised by Ms. Singleton. This case has been going on for a couple years now. And
so his
been
bond is old, it looks like. I'm looking
Correct.
for the bond. When you say October, it looks like it's October 2021.
Correct.
When he made bond.
And that's on the CP number. But the charges still mirror the indictment, so there's no difference on that.
Okay.
And we don't have to change that. We're asking that you reinstate the bond. I believe Ms. Singleton indicated that my client, she issued a warrant because my client failed to properly charge his monitor. And he has explained that the process for the monitor and his knowledge that it isn't properly charged. He said there was a shortage in the monitor, but he did not contact the monitoring company to inform them or to change it out, but that sometimes it wouldn't charge, and there's some way for him to know about it vibrating. But he said that he did attempt to charge the monitor.
Did he ever, if he was having trouble with things, reach out to anyone to say, how do I handle this?
No, Your Honor, he did not.
Okay.
Your Honor, he's 18 years old now. And like I said, this case has been going on for years. I'm the second attorney on the case. I believe his family hired an attorney at first. And I've been working on the case since October of 2022. And he indicates that he is on the in the Chris 180 program, the reentry program at the jail at this time, Your Honor. And he was doing okay when he was out on bond, except he did pick up a new charge. But I believe that if you were to reinstate the bond, he would be able to abide by the conditions of the bond and charge his ankle monitor. There were many conditions, as you could see from the October 2021 bond order, that he would be able to abide by. And the ankle monitor and the 24-hour curfew with the not the wraparound services, because now he's over the age. Once he turns 17, he can't get that, but he can have Ms. Singleton continue to pretrial monitor him and supervise him. And we're asking that, Your Honor, reinstate the bond as it, the amounts as it appears on the October 2021 bond order.
Okay. Quick question before you take a seat, just to see where we are procedurally with the case.
We have been arraigned on this.
Yeah, I'm looking. Did you do a waiver of arraignment? Maybe there was a formal arraignment, because I see you filed a substitution of counsel, asked for discovery. There's a scheduling order. So I know that means there's been an arraignment. My question was actually going to be, how is the state doing with discovery? Do you feel like you've got the discovery in the case, or are there gaps in it, or where are you and Mr. Peoples with that?
I don't note that I've received the discovery yet.
So on August 3rd, there was, it looks like you would have received an evidence.com link, if it went to you, that had a whole bunch of stuff. It did go to you, lists your name, and then there was the request for reciprocal discovery. So I guess I'd ask you to check. You don't need to do it right now, but just see if that link is out there. I guess Mr. Peoples could resend it. But since we're all here, I wanted to, this would be a good time to make sure there weren't issues from your side in terms of getting things. It looked like a pretty thorough delivery. There was a police report, field interview video, bunch of other things. So are you aware, Mr. Peoples, of anything that's outstanding?
The state isn't aware of anything outstanding. Defense counsel would have to let us know if there's anything missing or anything like that. As the court has just said, discovery was served back in August.
How long does that link work? Assuming Ms. Clark can get into her email and find what you or your colleague would have pushed across. It's now a month and a half ago. If she clicks on it, should it still be good, or do they expire?
It should still be active, Your Honor. If not, we'll resend.
It still should be active, Your Honor. I think it lasts about a year.
Okay.
That's correct.
All right. I'll send an email to both of you, copying Ms. Nelson, just getting you to confirm via email to me that you got it all, so that you and Mr. Hinton can start working through that.
Okay. And also, there is a concern about some type of indictment on the new charges, so that he wouldn't resolve this case and not resolve the new case.
I want to follow you. In other words, you're not particularly interested in having Mr. Hinton sort out this without a global resolution.
Correct.
Okay, makes sense. And I'm going to ask Mr. Peoples where he thinks that new charge is in Judge Drake's order that revoked your client's bond, Mr. Hinton's bond, in May of this year. She referenced the booking number, so there must be a CP number rattling around there. And we can see where that is in the process. Okay, thank you.
Okay. The new case, the CP number is 23 CP 218423.
Ah, great. Thank you.
Thank you. He's scheduled for a prelim on that one in October,
Okay,
if they don't indict it first.
got it. Mr. Peoples,
Yes, Your Honor.
your thoughts about reinstating Mr. Hinton's $45,000 bond, whatever size it was, $45,000 split bond.
Correct, Your Honor. The state would be opposed to that, Your Honor. As the court just stated, he was granted a $45,000 split bond back in 2021. And the reason for the revocation is the extensive issue with charging of the ankle monitor. As the court can see in Odyssey, in Judge Drake's order of revocation, and I won't read it out extensively, but several dates in October, several dates in December of this year, of last year, January of this year, into March as well. The state is also concerned about citing at least two of the IALA factors: risk of danger to the community and risk of committing new felonies, as it's alleged that in April of this year that a new armed robbery is committed. And the state is concerned that if Mr. Hinton is unable to abide by the parameters of this extremely reasonable bond that was set by Judge Drake, the state is concerned that he won't conform to any new parameters set by the court itself today. So we would ask that bond be denied, the reinstatement of bond be denied, citing risk of danger to the community and risk of committing new felonies. Additionally, with the ankle monitor I understand the defense is saying there were some issues. There's been no allegations that he attempted to say something was wrong with it. Out of all of these dates that were failed to charge, and therefore the state asked that reinstatement of bond be denied.
Okay, thank you.
Your Honor, may I just indicate that his new case, he was given a $40,000 bond on that case, so that if Your Honor reinstated the bond, his family would still have to post a monetary amount on the new bond, on the new case.
Interesting. I see that. So I want to get all the judges correct. Judges get a little touchy about, who granted bond and who didn't. It was Judge Borski, not Judge Drake, who issued the original $45,000 split bond. Judge Drake revoked that for two reasons: the failure to abide by the monitoring requirement because it wasn't charged over many, many months. And it's almost a footnote, just because she ran out of space, because she wrote so many dates when the monitor wasn't charged. A new arrest for, of all things, armed robbery. Judge Manning set a bond in the new case, the 23 CP case, $40,000, ironically, ankle monitor required. Mr. Hinton, I'm not reinstating your bond. For you to be on bond for an armed robbery and to pick up a new armed robbery charge says to me that we need to keep you where you are and sort out what's going on. I appreciate fully that you are presumed innocent in both situations, the one that's been indicted and the one that is merely a complaint. But the fact is, you've now been arrested not once but twice for armed robbery. And that second arrest was while you were out on bond for armed robbery. And I don't think that there is a set of conditions I could impose that would adequately protect the community from another situation like your more recent arrest, because you had an ankle monitor on, and that's typically what we point to as a way to make sure we can keep track of where you're going. Of course, if you don't charge your ankle monitor, it's hard for us to do that. So I'm going to deny the motion to reinstate bond. I'll get an email out to your lawyer and to the prosecutor to get confirmation in the next day or two that discovery did make its way to Ms. Clark. I'm happy, Ms. Clark, to put some pressure on the state if you and Mr. Hinton reach a point where you think the current case is capable of working out, to get that other case accused if your client wants to waive indictment, or at least let's get it indicted, because I appreciate your wise strategic decision to say, well, let's not sort this one out while that other one's rattling around. They're both serious charges. They may not actually have serious facts behind them, but it's two different armed robbery allegations, and Mr. Hinton understandably wants to resolve them in one place. And when that new case gets indicted, it's coming here anyway. So we might as well do it that way. Yes, ma'am.
Regarding the new case, since he has a preliminary hearing coming up in a few weeks, if they don't indict it, at least I'll be able to know what the allegations are.
Exactly. You'll know a whole lot more about it. And frankly, you and prosecutor will say it's the unindicted one that looks like it's a more compelling case for the state, or vice versa. But you'll certainly be able to do some fact gathering at the preliminary hearing. Okay. Anything else on behalf of Mr. Hinton?
No, Your Honor.
Mr. Peoples?
Nothing further on the statement.
All right, Mr. Hinton, well, I'll be seeing you soon. I'll make sure that your lawyer gets that discovery. Actually, she'll be seeing you soon because she's going to want to share with you what's in the discovery and begin to let you know her sense of the state has a real good case or the state's case isn't that good. And then you and your lawyer can figure out a way to move forward. All right. Ms. Singleton, did you need to weigh in any way since I'm not reinstating bond?
No, Your Honor.
Okay, I appreciate you being here. It's good to see you.
Good to see you, Your Honor.
All right. Thank you.
Thank you, Your Honor. Thank you.
Okay, final plea calendar. Many of you know this, but those who don't, all we're doing today, assuming there's not an egregious discovery issue out there, is figuring out if today is the day you're resolving your case. And if you are, you have the ability to withdraw your plea if the sentence that I pronounce is different from what your lawyer asked for. If you're not interested in working out your case today, we'll move your case to a trial calendar, and that's when I will see you next. Ms. Nelson, are all of these cases going to the same trial calendar, or we don't know yet?
I'm not sure, Judge. I would have to check as we go.
Thanks. Linda Seals is the defendant for the first two cases. Ms. Seals, if you'll come up either to the podium or to counsel table with Ms. Feely, please. All right, let's get on the record with positions 1 and 2. And the indictment in position 1, 22 SC 184128 charges Ms. Seals with terroristic threats. And her second indictment, 23 SC 187892, charges Ms. Seals with aggravated assault and a firearms charge. Ms. Feely, do you have all the discovery that you think is out there for the two cases?
Yes, sir.
All right. And has Ms. Seals received an offer from the state to resolve both cases?
We have.
Mr. Peoples, what is that offer if Ms. Seals wanted to sort her cases out today?
Your Honor, the global recommendation was 10 years to serve 3 and completion of an anger management course.
Okay. So Ms. Seals, if you were to enter a plea today, the state would recommend a sentence of 3 years in custody, followed by 7 years on probation. That's not what your lawyer would have to recommend, but that's what the state would recommend. Do you understand what the state's recommendation is?
Yes, I do.
Oh, okay. Ms. Seals, are you interested in moving forward today with a plea in either or both of your cases, or do you want me to move your cases to a trial calendar?
Trial calendar.
Okay. And Ms. Feely, that's consistent with the discussion you've had with Ms. Seals?
Yes, Your Honor, we're going to continue negotiations. I have some updates on Ms. Seals' health I would like to share, so it may work out, but at this point, yes. we're ready.
Okay. Share with the prosecution.
Well, whoever's,
The prosecution,
Right,
whoever it is. Clark, Ms. Clark, is going to, is that, I'm remembering the last name correctly?
That's correct.
Ms. Clark, is going to be the, try to be the new Mr. Peoples. Let me look up one thing. Oh, here it is. So Ms. Seals, you are going to be on our late October trial calendar. I think the trial would be in early November, but we're calling the trial calendar on October 27th. So about a month from now. You know how to get here. You've been here many times. You'll definitely need to be here that day, because that's when we'll be figuring out which of your two cases the state would want to move forward on first. They get to pick which of the two. We would then likely try that one of the 2 weeks of that trial calendar. Okay.
Okay.
So between now and then, you're going to want to stay in touch with Ms. Feely. If you've got questions or concerns, she's going to want to be talking with you to make sure everyone is ready for trial. Do you have any questions?
No.
Okay. Ms. Feely, anything else on behalf of Ms. Seals?
No, Your Honor.
Mr. Peoples, anything else?
Nothing further, Your Honor.
All right. Ms. Seals, I will see you either on the 27th or before then, if you and Ms. Feely are able to work something out with the state.
Okay, thank you.
You're welcome. Next up is Raven Young. Ms. Young, are you here?
Yes, sir. Yes, sir.
Good morning, Your Honor. Marcia Meany on behalf of Ms. Young. She is on the call.
All right. Let me add you and Ms. Young. You need to turn your video on. There you are. Add you to the spotlight. Okay. There's Ms. Young. There's Ms. Mignot. This is the final plea for Ms. Young. It's 22 SC 184713. We also have Mr. Belcher, a co-defendant. Do you want to do those at the same time, Mr. Peoples, or they're different situations?
No, Your Honor, it would be, the offer is the same for both of them.
Okay. Is Mr. Belcher here? He's right here. And how about your lawyer, Ms. Cabrera? Oh, there she is.
I'm here, Your Honor.
Great. Hey, Ms. Cabrera, how you doing?
I'm well. How are you?
I'm all right. Mr. Belcher, if you come on up, why don't you be at the podium and we'll have Mr. Peoples be over there and we'll handle both these right here. So Ms. Young and Mr. Belcher are co-defendants with Mr. Furlow. Mr. Furlow has already resolved his case. How did he resolve his case?
That's correct, Your Honor. He resolved his case, if the court will recall, through a guilty plea to armed robbery. I can't recall. He was represented by.
Me.
Ms. Wood,
Just a 2017 judge.
20 serve 10?
Yes.
Okay, great. All right, so Mr. Furlow has resolved his charges. Ms. Mignot, we reset this once. You were on leave. I think you're in the middle of a federal trial. But I think back then you had let us know that you had discovery in the case. It was simply your schedule was full and we weren't able to get you into court. I assume discovery is still good for you?
It was, Judge, until yesterday.
Okay, what happened yesterday?
There's a video referenced of the incident that was communicated in the affidavit that sought the warrant for my client. And I believe Mr. Peoples emailed yesterday, and I never got around to responding to him until this morning, that they don't have that video. So I'm concerned about what happened to the video. Was it destroyed? Because that's critical evidence. It's alleged to be video of the scene and the incident.
Okay, Mr. Peoples, what do you know about a video?
So, Your Honor, I've reached out to my investigator yesterday when when counsel let me know that it was missing. I don't believe that anything has been destroyed. We'll request it. I think that, it's something that can be resolved. When Attorney Mignot alerted us to let us know that it wasn't there, we reached out, or attempting to do so at this point in time.
Okay. So you don't have any reason to believe that a video has been destroyed. It's not in your possession.
That's correct,
And is it a body cam video or a surveillance video? What kind of video is it?
From Attorney Mignot's email reference, it sounds to be surveillance footage.
Okay. Ms. Cabrera, I'm assuming you're interested in the same thing?
I am. I haven't been able to reach Mr. Belcher again because I was trying to reach him. Sent him a text message and I tried to call him as well. So I wanted to confirm another good number and an emergency number for him because I wasn't able to speak to him between this weekend and this morning. I was still trying to reach him.
Okay. Well, we'll certainly get that from him. Let me add him to the screen too. There you go. You can see Mr. Belcher and Baby Yoda. So we'll get that from him before he goes. But it sounds like Ms. Mignot and Ms. Cabrera, you'd want to be able to review that video with your clients. Let's get on the record right now, at least what the offer is. It may change based on what's in that video. So everyone knows it could get worse for the defendants if the video shows something that's particularly inculpatory of either Ms. Young or Mr. Belcher. But what is the offer right now?
Your Honor, for both the defendants, the offer would be a reduction to robbery on count 1 and a null cross of counts 2 and 3, 5 years of probation, a stay away from each of the co-defendants and a stay away from the location as well.
Okay. That's good to get on the record that that's what the offer is. Any sense of how long it'll take to get the video?
Hopefully not long, Your Honor. I'm not sure. It shouldn't take long. It's not something overly complicated. So I would hope within the week or so, if something that is available.
Ms. Mignot, were you able to tell from the affidavit if it was video that the police had actually retrieved from the surveillance equipment at the location, or that they went into a rental office and watched it and said, hey, I looked at it and I saw the following?
It appeared as if they had gathered it, Judge,
Okay.
and shared with magistrate that they have it. And that's what threw up the red flag for me, that I had not reviewed it, nor had my client reviewed it. And to have her take a plea, as you're aware of the background story, I want to be very cautious as an attorney as it pertains to bar rules and making sure that I'm diligent about the client seeing the evidence before she actually accepts the offer.
Sure. No, that makes sense. And I think the same is so for Mr. Belcher. Okay. We will need to reset this. I'm wondering, because it's such an old case, if what we could do is move it to a trial calendar, but preserve Ms. Young's and Mr. Belcher's final plea rights, so that call of the calendar could also, for both of them, be a final plea opportunity. With an offer of 5 years probation, I don't know that the final plea rights are as significant, but they're certainly not using them up today if there's that piece of discovery missing. Ms. Mignot, do you have any objection if we nudge the case forward for Ms. Young to a trial calendar, but preserve her final plea rights?
No objection, Judge.
Ms. Cabrera?
No objection. I was actually going to ask if we could do something that would allow us to preserve their rights. That was going to be one of my questions this morning.
Yeah, no, by all means, this isn't something it sounds like it's an inadvertent failure to disclose, but you don't have this video. And so it's a reason to preserve the final plea rights. I think that's all we need to cover, other than getting Mr. Belcher to provide some contact information. Ms. Mignot, do you have anything else on behalf of Ms. Young?
Nothing further from the defense, Judge.
Okay, Ms. Young, you will need to be here in court for the trial calendar. So it's okay that you're virtual right now, but when I see you next for this trial calendar, you'll need to make sure that you get all the way to court, okay?
Okay.
All right, and Mr. Belcher, you made it to court, so you'll just need to be back here for that date. Tell me, do you want to write down good phone numbers and I can text them to Ms. Cabrera so you're not putting them on the record? Does that work? Is there a piece of paper there? Or do you need a note card?
But she gave me one.
Great. So if you would put an email address, your phone number, and then like a backup phone number of your mom or a significant other, because Ms. Cabrera needs to be able to reach you to let you know what's going on.
Yes, sir, Your Honor.
Great. All right, well, Ms. Young and Ms. Mignot, you two are free to go. We will see you for the trial calendar, but as I mentioned, I'll preserve the final plea rights in case that's something that we need to work through.
And Judge, do you know which trial calendar at this time?
Look, Ms. Nelson has been sending me texts. Yes, I'm not sure how these trial calendars are working. It says November 8th.
Thank you, Judge.
November 8th. So we'll see you at the latest then. Okay?
Okay,
Thanks.
thank you, Judge.
Enjoy your day.
Yep. What was your question?
When I previously spoke to you at Ms. Cabrera, there was speculation about me being taken off of my ankle monitor.
You still have an ankle monitor on?
Yes, sir.
How long have you been wearing an ankle monitor?
A while, to be honest.
I think he's had that ankle monitor on for over a year. And I think when he was in court before, it may have been discussed that he could have possibly had it removed, but I don't think he had counsel to argue for it.
Got it. Well, let me look. In April, we modified the bond. That lets you go to work, school, and church. Ms. Feely, you had the case for a little while. Why did you roll off?
I was actually just trying to.
Oh, maybe you just help with the bond modification order?
I think that was.
Okay, is it because I was gonna say, if Ms. Wood had okay, so because Mr. Belcher didn't have a lawyer, but he was working through all that. Okay.
But he comes to court and there hasn't been any issues. Like I said, I couldn't reach him, but it's not that he's never missed court.
No, he hasn't missed court. No. Okay. So you were one of the defendants who had Ms. Luncheon as a lawyer, and then she moved out of criminal practice. So then you were stuck. All right. Let me find your bond. So you got bond in October of 2020. Have you had the ankle monitor on for 2 years, or did you not get out right away?
I bonded out 5 months later.
Okay. But so you would have bonded out in 21, had an ankle monitor put on, and you've had an ankle monitor ever since.
Sure.
Okay. So I want to make sure I hear from you, Mr. Peoples. Do you have any objection to having the ankle monitor come off?
Just one moment, Your Honor. I'm just checking something.
Okay. Keep checking. You're writing down the phone numbers and the email address?
Oh, I have them, Your Honor.
You did it. Okay, great.
And Mr. Belcher has no record. I asked Mr. Peoples about that the other day. And so we confirmed he has no record.
Your Honor, I think if the state's recommendation is probation, and if the court is inclined to remove the ankle monitor, we would just ask for a curfew.
Okay. Well, I think there already is one, and so the only modification would be to remove the ankle monitor. Ms. Cabrera, if you can send a proposed order to Ms. Nelson and just copy Mr. Peoples on it, that modifies the bond by removing the ankle monitor, I will take care of that.
Okay, absolutely. Is it possible for Ms. Nelson to send me a copy of that bond order, because I don't have that? That way I can refer to it.
Yeah, I can do that. I just want to make sure there's not a more recent bond order. I don't think there was.
I think that's the last one.
You're talking about the one that modified the bond, or his actual original bond order from 2020?
Well, I guess if the one from April actually has all of his conditions, then that's sufficient. I just don't want to miss any of his conditions.
No, but you don't need to, all you would be saying is that the only condition that's changing is that he removes the ankle monitor and that all other conditions remain the same.
Absolutely.
Okay. All right. So Mr. Belcher, if you get to me, you can hand it to the deputy, your contact information. I'll get that to Ms. Cabrera. She will get to me, thank you, a proposed order that lets you take the ankle monitor off. Have you been able, when you needed to contact A&A Monitoring, whatever the company's called? So just reach out to them and say, hey, I've got this modification. Do you come to me or do I come to you? And they'll sort that out. They remove them all the time. So you'll just want to coordinate with them.
Would I be able to have that done as soon as today, Your Honor?
It's gonna be
So,
impossible for me to get to you.
yeah, I would say this week, but not
Right.
today. Is there something special happening tonight?
What? Nah, actually, I just received a new job.
Oh, good. You're doing
I received
what?
my second job.
Doing what?
Like I clean off tractor trailers. I clean out of tractor trailers, and that's an overnight job. So that was really one of my biggest concerns. And in the daytime, I work at Mavis Tires and Brakes.
When do you sleep?
In between.
In between.
After.
Okay. The answer is I'll take care of it as soon as I get it. Ms. Cabrera needs to put it together. It's not a big project, but I would say you should be able to get it off by the end of the week. And even if we got it to you today, A&A might say, whatever they're called, we can't see it till Friday. So we'll get the order out and then you'll need to coordinate with them.
Yes, sir.
Okay. Thank you for bringing that up. Ms. Cabrera, anything else for Mr. Belcher?
Nothing further, Your Honor.
All right. Thanks for your time.
Thank you so much. Have a good one.
You too. All right. So Mr. Belcher, you are free to go. You'll be back here on November 8th.
Yes, sir, Your Honor. Thank you.
Yep.
Yeah, thanks.
Moving right along. We have Mr. Rhodes. That is Mr. Adams and Mr. Hiles. Whoops, there's Mr. Rhodes. Add spotlight. Mr. Adams, add spotlight. There, we got everyone we need. Okay. Good morning, Mr. Adams. How are you?
Doing fine, Your Honor.
Good. Are you back? Were you overseas recently or you're going overseas?
I've gone overseas, I'm back, it was a great trip.
Excellent. Glad you decided to return. All right, this is 22 SC 185234, State versus Quindarius Rhodes. Mr. Rhodes and Mr. Adams are appearing remotely. We've got Mr. Hiles also back from a little trip. Did you have a good time?
I did, Your Honor. Oh.
There it is, a married man. All right, good luck with that. Mr. Adams, are you good with discovery in this case?
Yeah, we are, Your Honor, and we have a negotiated plea to present.
Oh, well, why don't we do that? And we're able to do that with Mr. Rhodes in the fan room there. He doesn't need to be here.
I don't have any objection. It's straight probation.
Great. Then let's dive right into it. Mr. Rhodes, we're going to get on the record in your case, 22 SC 185234. You are prepared to enter a plea in your case. Is that correct?
Yes, Your Honor.
Okay. Do you understand that you have a right to be here in court for this plea, but you can waive that right and appear virtually like you're doing? Are you waiving your right to be here in open court?
Yes, sir.
Okay. You also have a right to have Mr. Adams right next to you, so you could ask him any questions if things come up. He is not right next to you, but I can put the two of you into a private breakout room where you can speak confidentially. Are you willing to proceed with that setup?
Yes.
Okay. Well, if something comes up that you want to speak to him about privately, will you let me know?
Yes, sir.
Okay. Mr. Hiles is going to put you under oath. Once you're under oath, make sure you answer all his questions truthfully and completely. Okay.
Yes, sir.
All right. Mr. Hiles.
All right. Mr. Rhodes, will you please raise your right hand? Do you swear or affirm the testimony you give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, you put your hand down. Will you please state your true, correct, and legal name?
Quindarius Raymond Rhodes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicines?
No.
How old are you?
28.
What is your highest level of education?
12th grade.
Okay. Did you complete the 12th grade?
Yes.
Okay. Are you able to read, write, and understand the English language?
Yes.
Okay. Do you understand that this is a guilty plea to just count one of the indictment, which will be unlawful participation in criminal street gang activity, and that the recommended sentence of that is going to be 5 years of probation with the special condition of no contact with known gang members, no participation in criminal street gang activity, and no possession of weapons or replicas? Do you understand?
Yes, sir.
Okay. And do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, I understand.
And do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Okay. Have you been over the rights that you're waiving with your attorney today?
Yes, sir.
Okay. Have you had enough time to speak with your attorney, Mr. Adams, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Okay. Are you satisfied with his services?
Yes. Yes.
Okay. Mr. Adams, do you waive formal reading of this indictment?
We do.
And Mr. Adams, do you waive any and all defects in this indictment, including any with respect to your client's name for purposes of this plea?
We do.
All right. And Mr. Rhodes, have you been advised of the minimum and maximum sentence for the one count of participation in street gang activity that you are pleading to?
Yes.
And do you understand that this particular charge carries with it a potential sentence of 5 to 20 years? Do you understand?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation just stated to this court will be recommended for your sentencing? However, the court does not have to accept this recommendation, and the court can sentence you to the maximum on that charge. Do you understand?
Yes, sir.
Okay. Do you understand that if a court decides to enter a sentence that differs from this negotiated plea, you have the right to withdraw your plea of guilty? Do you understand?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts? Do you understand?
I understand.
And do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Mm-hmm.
Is that a
I need
yes?
a yes or no.
Yes.
Okay. Mr. Rhodes, are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to hold public office, the right to vote, and the right to obtain a passport. Do you understand?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I understand.
All right. Mr. Rhodes, I'm going to go over a set of rights that you're waiving, known as your Boykin rights. I'm going to go over each of these rights individually, okay?
Yes.
Do you understand that by pleading guilty, you are giving up the right to trial by jury?
Yes.
Do you understand that by pleading guilty, you are giving up the right to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the right to confront witnesses against you?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case? Do you understand?
Yes, sir.
Okay. Do you understand that by pleading guilty, you were giving up the right to testify on your own behalf and present evidence against others?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the right to the presumption of innocence?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the right to subpoena witnesses and compel the production of evidence? Do you understand?
Yes, sir.
And do you understand that by pleading guilty, you were giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the right to appeal if convicted of these charges after a trial?
Yes, sir.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Are you asking to take this plea pursuant to Alford or North Carolina versus Alford?
Yes.
And are you doing so because you believe that this plea is in your best interest and you are not admitting guilt, but acknowledging that there is enough in its evidence to find you guilty after a trial?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial? Do you understand?
I understand.
All right. Mr. Rhodes, how do you plead to the charge of participation in criminal street gang activity?
Guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have 4 years from today's date to file what is known as a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea? Do you understand?
Yes, sir.
Do you understand that unless counsel is substituted or permitted to withdraw, your counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later? Do you understand?
Yes.
Do you understand that you have till the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
Okay. Your Honor, were this case to go to trial, the facts would show that on September 1st of 2020 at approximately 5:48 p.m., Officer S. Stansel and J. Houston of the Atlanta Police Department attempted to conduct a traffic stop at the intersection of McWilliams Road and Jonesboro Road of a 2020 Dodge Challenger after they observed the car failing to yield on a left turn and almost striking another vehicle. The vehicle failed to comply with the stop and attempted to flee from the officers. It made a turn in front of traffic onto Midway Street, in which officers observed the car strike several curbs. After the last curb it struck, the driver, who was later identified as Mr. Quindarius Rhodes, fled from the car. However, the juvenile passenger was taken into custody. Officers conducted the search of the vehicle. In the vehicle, 708 grams of THC infused edibles, gummies, were recovered. 6.25 grams of liquid promethazine, 3.7 grams of MDMA, and some marijuana and a small amount of powder cocaine were recovered. The only drugs that we were able to, the GBI tested was the edibles. And I should also note that that 708 grams that was listed in the police report was including packaging and is not reflective necessarily of the actual amount of THC because they were substantially heavier based off of the food that it was infused with. During that search, the drugs were found inside a backpack. Next to that backpack, the officers were able to find Mr. Quindarius Rhodes' identification card, Georgia ID card, and the address, which was on Midway Street, right next to where the car was disabled, is where the car was registered to. Later that day, Mr. Rhodes was observed at that same address at 886 Midway Street when officers responded to a stolen car report. The grandmother of Mr. Rhodes had reported the car stolen substantially after this incident and chase of fleeing from police.
The grandmother reported her Charger.
Her Charger stolen.
Okay, so the 20 Challenger or Charger? I think I wrote Challenger, but whatever.
It was a Challenger.
Challenger. So that was grandma's car that Mr. Rhodes was driving.
Yes, and he was, the car was registered to her, and he was also the person that she stated was the last known driver of the vehicle.
Okay.
Your Honor, Mr. Rhodes is a member of the Young Slime Life criminal street gang. Mr. Rhodes has been observed on multiple platforms from Instagram to YouTube, displaying YSL gang signs and openly displaying firearms in front of known YSL strongholds in the South Atlanta neighborhoods along Cleveland Avenue. Also taunting and making threats towards rival gang members. Mr. Rhodes is also an aspiring rapper who goes by the rap moniker Young Slat, SLATT. Slat is a direct reference to the gang Young Slime Life, standing for slime love all the time. Your Honor, that would be the state's evidence should this case have proceeded to trial. And I should say, if Your Honor accepts the guilty plea, that the remainder of the counts will all be null prost.
Okay. We lost Mr. Rhodes. Let me get him back on there. I don't know what happened. There he is. Okay. Let me ask Ms. Roberts. Good morning, Ms. Roberts. Can you share with me whatever information, if any, you've got in terms of criminal history for Mr. Rhodes?
Yes, good morning. I'm showing a total of 16 cycles, 1 out of Alabama, 15 out of Georgia, a 2019 conviction out of Fulton County for possession of cocaine, and possession of a firearm. I'm loading the case number. 19 SC 167508. It was possession of a firearm during the commission of a felony. And I show a first offender. I'm not sure if that first offender was sealed. 14 SC 130765. That was for what is these loading kind of slow?
I believe it was for possession of cocaine. It was a non-complex case and it's run its course.
Okay.
Yes, that's correct. Thank you. Nothing further.
Okay. What was the most recent arrest that you found?
My computer's moving really slow, and I think it's because I need to grab my charger. The most recent arrest prior to this one would have been.
Oh, if there's nothing, if this is the most recent, the September 2020, that's all I need to know.
No, I'm showing December of 2021 for unlawful person employed or associated with criminal street gang to conduct or participate in criminal activity. If that's this case.
Your Honor, I can. Oh.
Okay. Yes, Mr. Hiles.
So I believe those were warrants that were issued over a year after this initial arrest. And so he was arrested on warrants, but it was involved this incident. Yes.
Got it. Okay. Thank you, Ms. Roberts. Mr. Adams, what do you want to add?
Yes, Your Honor, he is employed at a warehouse. We think this is appropriate resolution. We ask that you accept the recommendation.
All right. Mr. Rhodes, where do you work?
At a warehouse. I think it's the Canada warehouse.
How long have you worked there?
I've been with the temp service for over a year, but I've been moving around to different warehouses.
Got it. So the temp, they find you something that might last for a month and then you bounce to another spot.
Yeah, it might be 3 months, then 2 months. They just bounce you around, but it's working.
Okay. What kind of hours? How many hours a week do you get?
What is it, like 8? Like 40 hours a week.
Okay, so it's a full-time job.
Mm-hmm.
Okay. All right. Mr. Rhodes, anything you want to add to what I've heard?
No, sir. I'm trying to do right. Get on the right path.
How is the whole Young Slat thing going? You still out there recording?
Yeah, but I just drop music. I just get my royalty checks.
Okay. And is that enough, or you still also need to have this warehouse job?
Oh, no, I just got the job for probation.
So do you make enough off the royalty checks that if you weren't on probation, you would not be in the warehouse?
Yeah.
Oh, okay. Interesting. All right. You have any questions about anything we discussed?
No, sir.
Okay. An offered plea, Mr. Rhodes, is when a defendant says, I don't necessarily agree with everything the state has to say about my case, but I also want to take this offer and don't want to go to trial. Does that describe your situation?
Yes.
Okay, I'll accept this as an offered plea. I find there's a factual basis for your plea and that your plea was knowing and voluntary. Voluntary means no one's forcing you to do this, and a knowing plea just means you understand what we're talking about. Do you agree with both those things?
Yes, sir.
I'm sentencing you under the Probation Options Management Act. And what that means is that while you're on probation, if you have a minor violation, something small, you and probation will sort that out. But if it's a bigger deal, you violate one of the special conditions of your probation, in this case, that will come back to me. Mr. Adams, is it okay if my staff signs Mr. Rhodes' indictment on your behalf?
It is, Your Honor.
Mr. Hiles, can we sign for you?
Yes, Your Honor.
And Mr. Rhodes, if you were here in court, I might have you sign the indictment saying offered plea, but you are wherever you are right now. Is it okay if we sign for you?
Yes, sir.
Okay. Mr. Rhodes, what I'm going to do is sentence you to 8 years of probation. I'm going to tell you why 8 in just a minute, but I'm also going to set what's called a behavioral incentive date, which closes out your case of September 20th, 2027. So that's 4 years from now. If you have done fine on probation for those 4 years, they can just shut it all down. No more probation, no nothing. I want a little extra time because in my experience recently, the hard part of your sentence is not going to be you not getting arrested. You haven't done that for a while. It's going to be you maybe not hanging out with some of the folks who got you mixed up in some of this stuff. One of your special conditions is no participation in gang activities, and the other is no contact with known gang members. That doesn't mean you can't go out and perform and make better money than in a warehouse, but it does mean that if we get together in a year or 6 months or 3 weeks, and Mr. Hiles has obtained through investigative techniques all sorts of Instagram or something else showing you with guns and cash and guys that he can point out saying, that's not a musician, that guy's a gangster, that guy's a gangster. That's going to be a problem for you. And I share that with you just to make sure you understand what we're talking about. I don't mean to be up in your business. I'm thrilled if you make good money dropping tracks and making music and all that, or moving boxes around in a warehouse. I just want to make sure that you are doing that in a different way than you were maybe 3 years ago. Does that make sense?
No, I understand. I overly understand you.
Any questions about anything I said?
No.
Okay. Were there other conditions? I said special condition 1, no contact with known gang members, and then 2, no participation in known gang activities. Oh, and you said no possession of firearms, actual or replicas.
Yes, Your Honor.
All right, no squirt guns. Don't mess around with those.
All right, I got you.
I bet you can do that. Mr. Adams, do you have anything else on behalf of Mr. Rhodes?
No, Your Honor.
Okay. Mr. Rhodes, are you on probation right now?
My probation should be sealed. I completed my first offense.
So why didn't you quit working at a warehouse? You like it too much?
No, I knew I was gonna get probation for this, so I had already got a job.
Well, look at you planning ahead. That's a good choice. All right. Mr. Hiles, anything else?
No, Your Honor.
Ms. Tucson works with the probation folks, Mr. Rhodes. She will not be your probation officer, but she's going to coordinate getting you connected with a probation officer. Ms. Tucson, what information do you need from Mr. Rhodes?
Good morning. I will need your address, Mr. Rhodes. I'm sure what we have on file,
It's the same one
from your previous probation case. It is the same one.
Yes,
Okay,
886 Midway Street.
second.
Can you
Residence.
repeat the address, please?
886 Midway Street, Atlanta, Georgia, 30315.
Yes, ma'am.
Okay, what's your phone number?
404-268-5816.
404-268-5816.
Yes, ma'am.
And this is your direct number where I can call and give you instructions for reporting?
Yes.
Okay, because now they're doing the intakes. The officers will be calling you after I speak to you about the reporting instructions. So just to make sure that it's a verifiable address, correct?
Yes.
Okay, then we will contact you for intake, okay?
All right. Thank you.
All right, no problem.
All right, Mr. Rhodes, you are free to go. Good luck with everything. And now the whole world knows young Slat's personal phone number, so you may get some fan-based calls.
All right,
Take care.
Thank you, Your Honor. May I be excused?
Yes, sir.
Okay, thank you.
All right, next up is Mr. Newton, who I think is in custody. If we could bring him out. We've got Mr. Arrington here. I apologize keeping you all waiting. I'm going through the calendar in numerical order, but I think I got an email that there's a pending immunity motion. So unless we're working the case out today, I made you and your entire GJP team wait around to say, don't you want to resolve the immunity motion before we do final plea?
Well, not quite, Judge. We can maybe do you one better.
Okay.
The state's extended a plea offer, not just for the case.
You keep talking. I mean, he's working his way out, and we'll get all this on the record when he's here.
The state has made a plea offer, not just for the case on the calendar that's indicted, but Mr. Newton's other 3 unindicted cases.
A 4-for-1 deal.
4-for-1.
Okay.
So we are interested in taking that. We are close to getting Mr. Newton signed up. We just have to do our due diligence with those unindicted cases, going over some of the discovery we've received and some that Mr. Peoples is still trying to get for us.
Mm-hmm.
So to that end, today we're asking to be reset to your Friday calendar.
Okay.
And in the meantime, we would like to go do a contact visit with Mr. Newton, to sit down with him with a computer to look at these surveillance videos, sign all this paperwork, really prepare him for the plea itself, which does include custodial time.
Okay. Yeah, maybe with 4 cases, it might involve custodial time.
Yes.
That all sounds good. Closure for everyone is a good thing. Let me look at Friday. It looks like we've got some real estate in there. Ms. Nelson will have to bless it, but she's right back there. So that would mean we could cancel the immunity hearing. I think that's with Judge Dempsey, but that's not between now and Friday.
Correct. It's scheduled for
October the 3rd.
Oh, so that's plenty of time. We can get it. We'll see what happens on Friday, because if Friday falls apart, you want to keep the immunity hearing open. So we won't do anything too hastily. I just wanted to make sure it wasn't between now and then. So I don't know what the hang up is with getting Mr. Newton out here. We'll get him out here.
Mm-hmm.
I'll explain what I think the plan is. If you get me, and that may be what's in your hand, a proposed order to get you a contact visit with Mr. Newton, we'll get that e-filed today.
Sure. Can I approach?
Sure.
Thank you.
Sure, that was easy. Thank you. And Ms. Feely, I see that you continue to work on behalf of Mr. Belcher.
It's just easy to do.
Gonna have to send you a holiday card. After you answer a question about Ricky Wolf.
Yes.
So we'll all be together tomorrow. And Mr. Manetas had said he thinks that that's a plea,
Yes, that is my understanding.
because it's a speedy. And that's what we go out on first if it doesn't resolve tomorrow.
That's fine.
Your plan is that it goes away. Okay. And there's the big one, and then he's got like 2 or 3 theft by receivings. Whatever the plea is, closes out all his business. Excellent. I'll see you tomorrow.
And then, Mr. Bath as well.
Yeah, well, that's how I was learning about it, because Ms. Wood said, we are hoping on the coattails of that to have Mr. Batten's situation.
It's
So,
my understanding that Stephen was you guys.
good.
So, but I think he's actually gonna be on
Mr. Manetas will be virtual. Ms. Wood will be here in person, I think, I hope. You'll be here in person. And it will be the first plea we take after I call the calendar, just because of the speedy, because then I'll know, okay, we have other options, but otherwise we got to make sure we get the trial in on this calendar.
For what it's worth, it's the state's position that speed trial is well out of time.
Okay, well, we could litigate it if necessary. Out of an abundance of caution, I'm treating it like the hot potato it looks like, and but it will all be moot if things go as you forecast for tomorrow.
And if you have at least one, maybe two victim impact statements, they will be present on Zoom. The victims next of kin reside in California.
Fantastic. I mean, sad for them, but we'll certainly incorporate them in the proceedings tomorrow. And well, you should let them know if they're coming from California virtually. If I shouldn't do it right off the bat, I won't. That's 6 a.m. for them. I'll call the calendar first and get through it just to get everyone's announcement. But I am expecting a fair number of pleas tomorrow. And I want that to be one of the earlier ones, just so we know what the landscape looks like for everyone else's cases. Okay, so just see how early they can get on a Zoom call.
Will do.
Please. And then we need to get Max Pritchett into court for 404B or whatever it is. Okay, you are free to go. Thank you. Hey, Deputy Gordon, I know you don't work in here anymore. Why can't we get Mr. Newton out here? Oh, do we not have everyone up? When are you coming back? Well, when did they bring everyone up? Sorry, Mr. Arrington, I didn't mean to leave you hanging there. I assumed everyone was up.
He was earlier, Judge, but
you've already talked to him today?
we talked to him this morning. Yeah.
Up here?
Yes, sir.
Okay, I don't get it. While we're waiting, why don't we do, I think Mr. Richardson is on the call. Mr. Richardson, you there? He is.
Yes, I am, Your Honor. Good morning.
Hey, we will get Mr. George's situation more fully on the record. Is that a plea today or not a plea?
That is not a plea today, Judge, and the state has provided me with all of the discovery. The state has provided me with a recommendation that I believe is very reasonable. The problem is I've been out of the country for a few weeks and I'm just now getting back into the office. I need to meet with my client, convey that offer. But I anticipate, Judge, a resolution on this. If you could just set it down for another hearing, I believe I'll have it resolved by that time.
Let me check something. Oops. Position 7. Mr. George, are you YC Barron?
Yes, sir.
Okay, just want to make sure. Let's just close this out since I've got you all here. There's Mr. Richardson. Let me get your case up. There's the answer. Okay, here's my proposal, Mr. Richardson. Mr. George is going to appear on our October calendar about a month from now, about a month and a week. My thought would be, assuming Mr. Peoples is willing to leave the offer open, and he'll need to memorialize it because he will not be on the case by then. He is being elevated to one of the specialized units. But if he's willing to keep the offer open, why don't we freeze everything to include Mr. George's final plea rights, and just know that we will see you and Mr. George and Ms. Clark, who will be replacing Ms. Peoples, for what sounds like a plea, either before the trial calendar, if you arrange something with Ms. Nelson. I'm happy to take it before then, but the known date that we've got is that October 27th date.
Okay, Judge, and I'm not trying to be difficult, but I have a specially set case on October 23rd before the Honorable Judge McLean over in Douglasville. I know that case is going to last at least 10 days. Is there any way we could be placed on another calendar?
Yes, there is. And what I'll do is ask Ms. Nelson to coordinate with you so that we get it on your schedule. And you'll need to be a little flexible with us because you kind of boxed us in with can't do it today. And here we are. Can't do it on the 27th. I know you'll be in front of Judge McLean, but I'll have Ms. Nelson reach out to you, assuming Mr. Peoples, the state will leave its offer open to whatever magic date that ends up being.
Yes, Your Honor, the state will do so, and I'll make notes in Odyssey for Attorney Clark as well.
Okay, so we'll reset this for a likely plea. That's what it will be on the calendar for. Mr. George's final plea rights will be intact. And that plea date will be sometime between today and the start of Mr. Richardson's specially set calendar in Douglas County. Mr. George, does that make sense? We rattled off a bunch of procedural things, nothing about the facts of your case, but did you follow all that?
Yes, sir.
Any questions about any of that?
No, sir.
Are you dialing in from Georgia or are you far away?
I'm in Georgia.
Okay. And Mr. Richardson, where were you when you were not in the country?
Your Honor, I had the honor of celebrating my 35th year with my wife, and we started off in Rome. We went to Venice, then to Naples. We went to Croatia, and ended up in Athens. And it was the greatest experience that I've ever had in my life. So, but thank you for asking.
Well, congratulations. You maybe didn't want to list all those things. Mr. George is wondering why he's paying you so much, but that's okay. He's glad that you're back and that you're trying to work his case out. So I'll get with Ms. Nelson. She'll get with you. We'll figure out a date for Mr. George to be back here, and we will hopefully sort the case out. Mr. Peoples, anything else for the state?
Nothing further from the state, Your Honor.
Mr. George, anything else from YC Barron?
No, sir.
Okay. Mr. Richardson?
Thank you, Your Honor.
All right. Thank you all. You're both free to go. All right. Yes.
He's up here, Judge.
He is here. So Sergeant Lattimore, did you take him all the way back down? Okay. All right. Well, we're glad he's here. And we don't need to take any of this down. Mr. Newton, I'm Judge McBurney. How you doing? Good. Here's what I talked about with your lawyer and the prosecutor, I think is the plan. You've been a busy guy. You have not one, but 4 cases. 1 has been indicted, assigned to me. The 3 unindicted ones, the state has agreed to roll up into an overall, they call it a global resolution. So if you decide to go forward with a plea, it would take care of all that business, all 4 cases. Mr. Arrington wisely wants to spend a little time with you with the discovery in those other cases. It may involve some videos just so you can see what he's seen, so that when he recommends a particular course of action, you don't look at him like he's got a third eye right here, but that, like, okay, I get it. I see what's in this video too. We need to work these cases out. So I'm going to sign this order right here that will give him direct access to you at the jail so he can bring out, I think you've had one of these visits before, where he can play you some of the videos, et cetera, that relate to your cases. And his request, Mr. Arrington's, was that we get back together on Friday, same place, right here. You'll probably be dressed the same. And we will see if we can resolve all 4 cases. So not today, but on Friday. And if we do that, then you'll be on your way. Does that make sense?
Yes, sir.
Was that what you were thinking was going to happen?
Sir.
Great. Any questions about anything?
No, sir.
Mr. Arrington, anything else we need to talk about at this time?
No, Judge.
I'll get the order in the system, and that should enable you to meet with you and half of the Georgia Justice Project going on in there to meet with Mr. Newton. Okay. All right. Full squad. Mr. Hiles left. Mr. Peoples, anything else?
It's my case.
It is your case.
Nothing further, Your Honor.
Great. Okay. Mr. Newton, then if everything goes smoothly, I will see you on Friday for a plea. Any questions for me right now?
No, sir.
No? Okay. See you soon.
Thank you, Judge. Maybe we'll see you tomorrow. Maybe excuse Your Honor.
You can go. I don't know about everyone else. They do what they need to do. Hey, you guys sent out a very impressive email about the grandfather who passed away. I hope that went far and wide. That was very well written.
Thank you, Judge.
Did you write it?
No.
Okay.
Yeah, someone far more skilled than I did, but it was really touching.
It was very well done.
Thank you.
Reset for Friday. All right. Quandacia Jackson is next. Is Ms. Jackson here?
She is not, Your Honor, and I am going to continue to try to reach her. I was expecting her today.
Okay.
But if I can get a hold of her, would it be okay to have her walk in this week?
Yes, I will be receptive to processing bench warrant paperwork because this is a final plea. It's not an arraignment, but Ms. Jackson can address all of that. Had she been here today, were you expecting that the case would resolve? Because that makes the bench warrant a little trickier.
I did not, but I thought we could continue to work on it. It's for a case from 2019.
Oh, just new indictment, old charges. Oh, it's an aggravated assault, of course. Okay.
And Your Honor, the time being 10:50, the state will ask for additional.
Okay, and I think that's a well-placed request. If Ms. Jackson makes it later today, we can always handle the proceedings or later this week. But Mr. Peoples, you should have your team begin processing the bench warrant paperwork and get it over to Ms. Nelson.
Yes, Your Honor.
Floyd Mize should be here and hopefully up.
He's here, Judge. I spoke with him. He's considering a non-negotiated plea today, so I will step back and. we could come back.
Check with him.
Yes.
Okay, let me see if you don't have, you should go talk with him. Okay. Then we've got Matthew Chalmers. Hey, how are you, sir? It's been a minute.
It has, Judge, absolutely.
We'll get Mr. Chalmers out in just a minute. There's a co-defendant. Is he a fugitive, Mr. Abate? Because he's not on this calendar, which is odd.
I thought he had been arrested, but I can check.
I'll look too. Says warrant judicial hold. No, okay.
No, well,
Well, he'll need to come out. If he can come out now, well, that's happening, great. If he can't, we'll wait. I just was seeing what was happening. Okay, great. And then finally is Mr. Hardaway. Is he in court? Or online? I see Ms. Rockwell. I don't, oh yeah, he is too. Okay, you guys don't need to turn on yet. We'll get to you. Okay.
yeah.
All right, Ms. Rivers, we're gonna get on the record with position 10. It's 23 SC 187611, State versus Matthew Chalmers. Mr. Chalmers is charged with murder and related counts, and this is his final plea date. Mr. Partridge, you feel like the state has gotten you all the discovery that it can right now? There may be some GBI reports that are outstanding, but other than that, you doing all right?
I believe that's exactly where we are, Judge. Some GBI stuff that may still be outstanding, but otherwise, I think we have a clear understanding of the case with discovery, Judge.
Okay. Are any of the GBI reports what I'd call dispositive? In other words, you get it like, great, my guy walks versus, now we need to work it out. And I ask only because sometimes lawyers say, it's kind of hard to do this final plea right now because the state has said, if it comes back negative, we'll offer you 10. If it comes back positive, it's life without parole. And oftentimes the GBI reports don't move the needle at all because it's all on video or there are 100 witnesses. Right. I'm just curious for you, where you think this case is.
I think we'll have further talks once we receive that information, Judge.
Okay.
As it relates to that. It's our understanding with the co-defendant, there might be some stuff regarding him as well as it relates to the GBI report. So we'll wait and continue to speak with the state about it.
Okay.
A resolution, shorter trial if we can reach one.
Got it. Mr. Abate, is the offer right now anything other than pleading to the indictment?
Not at this time, Your Honor.
Okay. All right. So Mr. Chalmers, if you wanted to resolve your case today, You could, but it would involve pleading to the indictment, which is pleading to murder, which means the smallest sentence I could give you is life. Most folks don't plead in a situation like that. Later on down the road, you might, because of the strength of the state's case or who knows what. Are you interested in resolving your case today by way of a guilty plea? I need you to speak out loud.
No, sir.
Okay. Then what I'm going to do is move your case to a trial calendar. And when I see you next, we'll be talking about, is it going to be a trial? We'll get 12 jurors in here, or is there some non-trial resolution, which would mean a plea? Your lawyer is going to continue to negotiate with the state. Sounds like there are a couple pieces missing. Mr. Abate, what do you think is outstanding from, sorry, I hadn't turned those on earlier, the GBI?
Your Honor, the most significant thing that's outstanding is shockingly the ballistics evidence being tested by the firearms examiner. In this case, it's much more important than in previous cases that I've announced on where this is missing. There was a total of 25 shell casings, and what I believe to be numerous guns used. The testing of those shell casings will determine how many people shot. So I think that's important for this case based on the totality of the factual circumstances. So I would request for the benefit of both parties that Mr. Chalmers' final plea be
Preserve his final plea rights?
yes, Your Honor, I'm sorry, I'm off my words, for the trial calendar. That way, if something earth-shattering comes through with the ballistics evidence, we're able to offer him something different. And he'd have the opportunity and the rights that he would have here today.
Okay. I think that's a reasonable request. It does sound like the ballistics information may change the way one or both sides weigh some of the factors in the case. This case right now is supposed to be on the November 8th trial calendar. Do you need to think, Mr. Abate, about shifting the ballistics to the outside expert, or, well, I'm just letting you know, it's on the November 8th trial calendar. So that's not quite 2 months away, but it's a little ways down the road. I know you work hard to pry results out of the GBI, but it's now on everyone's radar. And it may be that Mr. Partridge is just as interested as you in saying, well, we need a continuance because we don't have results. But if he is not interested in a continuance and said, no, I want to go forward in the absence of those results, that's just something you'd need to be able to negotiate, navigate come November.
Yes, Judge. I will follow up the GBI at the end of the day. Now that I have a hard date for the trial calendar.
Yeah.
I think Mr. Partridge's current state of being in 1D may help us with the time.
Yeah, 1C. Emerson gets D, Glanville gets C.
I think that may assist.
I didn't realize. We're glad we got you right now.
Yes, Judge.
You don't have any, I figured you have more gray hair as a result of that.
Starting to thin out.
Yeah.
A little
Yeesh. Okay, that will complicate things as well. I trust you and Mr. Chalmers are in regular communication about that. He has elected to have you as his lawyer, and he's lucky to have you as his lawyer, but that carries with it a consequence of limited availability.
Yes, Your Honor. And I've tried to be available as much as possible, obviously.
Right, for something like this.
Yes, Judge. So we're definitely in communication. As family, they have personal cell phone numbers, so we're talking often.
Okay, well, that won't take it off the trial calendar. In other words, we'll keep it there just so that things keep moving. But I appreciate fully that it may be that your announcement on the November trial calendar is, it's great that we got the ballistics, but we actually are picking a jury now, or whatever phase you're going to be in come November.
Yes, Judge.
Okay, Mr. Chalmers, we did most of the talking here. I know you've been listening. The way I see it, you'll be back here on November 8th. I'll see you again and we'll see what's going on. The state may well announce ready for trial, but your lawyer may say, I'm not available for Mr. Chalmers because I'm stuck down in 1C or wherever the proceedings are at that point for the YSL RICO trial. You understand that?
Correct. Yes.
Okay. All right. I just don't want you to, when I see you on November 8th, to say, what do you mean my lawyer's not ready? And ready is the wrong word. My guess is he'd be ready to try it, but he wouldn't be available to try it because he's got that pre-existing long-term commitment with the YSL trial. Okay, so I don't want you acting surprised when I see you again. If that issue comes up, anything could happen. His guy could plead, Judge Glanville could sever his client out, and then we get 100% of Mr. Partridge's time.
Absolutely.
Okay. Mr. Abate, anything else in Mr. Chalmers' case?
No, Your Honor, I'll just let the board know, my plan is so that GPI continue to be the one who tests instead of taking to a private examiner due to all the circumstances, the state county resources.
Sure. Well, and it's a bunch of shell casings. It's not one.
Right.
So, okay. All right, Mr. Partridge, anything else on behalf of Mr. Chalmers?
The only other thing, Judge, we filed a bond motion reconsideration. He was denied bond before the court before. So that's the only thing that's pending. I'll get with Ms. Nelson to schedule that.
Get a date for that.
Yes,
Okay,
Judge.
good. Just so the state has notice so that victim family members can plug in if they choose to.
Absolutely.
So I may see you, Mr. Chalmers, before November 8th, if I decide to have a bond hearing for you. Otherwise, November 8th, we'll talk about trial. Okay? All right, thank you.
All right, man. I'll see you, man.
Yeah, that.
You may. Is Ms. Wood ready, or should we've got a case where everyone's on bond?
She's ready, Your Honor.
Okay.
Yes, ma'am.
Ms. Wood, are we moving forward with a plea?
Yes, Judge, it's non-negotiated.
Okay. Well, let's get on the record. This is State versus Floyd Mize, 23 SC 187490. Good morning, Mr. Mize.
Good morning, sir.
I'm Judge McBurney, and you are here on your final plea date. What that means is that it sounds like you're about to enter a non-negotiated plea. Ms. Marsh, who's the prosecutor handling your case, is going to make a recommendation. It sounds like it's going to be for a more severe sentence than what Ms. Wood is going to ask for. I'll be then confronted with two options. I actually have a lot of options because I can go somewhere in between. I could go more than Ms. Marsh. I could go less than Ms. Wood. If I sentence you to more than what Ms. Wood asked for, more probation, more jail time, a larger fine, whatever more might mean, the two of you will have a chance to discuss it. And then if you want to withdraw your plea, you don't need to explain why. I'll get why. It's because you don't like the sentence, but you can withdraw it and it's like it never happened. And then we will move your case to a trial calendar. Okay. So I just want to make sure you understand today and today only, you have the ability to back out of the plea if the sentence I impose is greater, more severe than what Ms. Wood asked for on your behalf. Do you understand that?
Yes, sir.
Great. Then that's what we're going to do. When you're answering questions, for a court reporter to hear you, I need you to use your outside voice. Right now, you're using your top secret voice, and that's not going to cut it. She needs to be able to hear you. You don't need to yell, but just make sure you're projecting. Okay?
Yes, sir.
That was much better. Ms. Marsh, when you're ready.
Thank you, Judge. Mr. Mize, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. Please lower your hand. State your true, correct, and legal name.
Ma'am,
Please state your true, correct, and legal name.
Floyd Ernest Mize.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
46.
And what is the highest level of education you have completed?
11.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that for this indictment ending in 490, you are currently charged with 1 count of state sex offender registry violation?
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to review the waiver of rights form with your attorney?
Yeah, I don't know, Ms. Marsh, it's a great question. But we have stepped back a little bit from using my waiver form, and we're going to need to talk as a team about whether we want to bring that back. So what's been happening more typically is that the lawyer has a conversation with her client about the rights that are given up or waived when we go forward with a plea. So, Mr. Myers, we're not hiding anything from you. There is a form that traditionally I've used where you're going to initial next to, I give up my right to trial by jury. I give up my right to subpoena witnesses, to cross-examine witnesses testifying against me, all that kind of stuff. Ms. Marsh is going to cover all that verbally in court right now, but we usually do belt and suspenders, or historically we did. And so a lot of what Ms. Marsh would be asking you about in court, you also would have already initialed that you understand that. Today, we're going to forego the written version. Okay?
Yes, sir.
Understood, Judge. Thank you for that. So being that we're going forward with this non-negotiated plea, would Your Honor like for me to maybe switch it up and go through the factual basis first, or finish the colloquy?
No, colloquy, your recommendation, factual basis. I'll get criminal history from Ms. Roberts, and then I'll hear from the defense.
Okay, understood, Judge. Thank you.
Sure.
Sir, have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding this charge and this indictment, including any potential defenses?
Yes, ma'am.
Do you need any additional time to discuss the case with your attorney?
No, ma'am.
And are you satisfied with your attorney's services?
Yes, ma'am.
Ms. Wood, do you waive formal reading of the indictment for purposes of this plea?
We do.
And do you also waive any and all defects in the indictment, including with respect to your client's name for the purposes of this plea?
So waived.
Mr. Mize, do you understand that for this charge in this indictment, the range of punishments that you're facing is 5 years to 30 years to serve?
Yes, ma'am.
Do you understand that this is a non-negotiated plea, and so the state will recommend a sentence to the court and your attorney will do the same, and then the court will impose a sentence as it so chooses?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if the court places you on probation or parole of any kind, on probation of any kind, you cannot violate any criminal laws of any governmental unit or violate any special conditions of probation without being subject to the revocation of the balance of your sentence?
Yes, ma'am.
And do you also understand that should the court impose any sentence of probation, you will not be allowed to possess nor use a firearm while on probation?
Yes, ma'am.
Further, this is a felony, so you would not be able to possess a firearm in any event. Do you
Yes,
understand that? Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be several adverse or unfavorable consequences as a result of entering this guilty plea today? For example, for this conviction, this may have an impact on your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, as well as your ability to obtain employment. Do you understand that, sir?
Yes, ma'am.
Do you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Say that again.
Yes, sure. Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
So these are kind of the rights that we were talking about earlier. I'm going to go through them with you here. Do you understand that by pleading guilty, you're waiving the right to a trial by jury?
Yes, ma'am.
Do you understand that you're also waiving the right to remain silent and not incriminate yourself?
Yes, ma'am.
You are giving up the right to confront witnesses against you. Do you understand that?
Yes, ma'am.
Do you understand that you are giving up the right to assistance of counsel at a trial of your case?
Yes, ma'am.
Do you understand that by pleading guilty, you're also giving up the right to the presumption of innocence?
Yes, ma'am.
Giving up the right to testify on your own behalf and to present other evidence?
Yes, ma'am.
Do you understand that you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes, ma'am.
Do you understand that you're giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, ma'am.
And lastly, do you understand that by pleading guilty today, you're giving up the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am, they haven't.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the sole counts, count one, in this indictment, state sex offender registry violation?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have 4 years from today's date for this felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
And do you understand that that filing must be filed by your attorney unless you're otherwise representing yourself?
Yes, ma'am.
Thank you, sir. Your Honor, the state expects the evidence to prove in this case that in 2008, specifically May 29th of 2008, Mr. Wise entered a guilty plea to the offense of sodomy. That sentence he received was 20 to serve 13. With the balance probated, and as part of that sentence, Mr. Wise was to register as a sex offender. Your Honor, Mr. Wise, for the purposes of this indictment, did not register for his 2022 registration as he was to do within 72 hours of his date of birth. But Your Honor, I would like to give you additional information, being that this is a non-negotiated plea. Your Honor, I understand that you're going to get some additional criminal history information from probation. However, this is Mr. Mize's third state sex offender registry violation. He had a conviction in 2015 for failure to register in Lowndes County, Georgia, for which he was sentenced to 4 years on probation. Most recently, he had a failure to register in 2018 that was out of Cobb County, where he was sentenced to 5 years to serve. Your Honor, I was able to pull up some of Mr. Mize's history while he's been in the Department of Corrections. And what it appears to show is he got out of custody of that for that aggravated sodomy September 8th, 2014. Failed to register, served time for that failing to register, and was in custody, in DOC custody at least, from October 14th, 2015 to February 4th, 2017. Again, got out, failed to register, and was incarcerated again in DOC custody from April 2018 to May 2022. He was due to register on August of 2022, so shortly after he got out, and again failed to register, Your Honor. So this appears to be a pattern. For the purposes of that pattern and to give a resolution that the state believes fairly and accurately captures that, the state is recommending 5 to serve 2 with the balance probated, a $500 fine, and for Mr. Mize to be in full compliance with the state sex offender registry within 72 hours of release. Your Honor, this is a second or subsequent, so the range of punishment is 5 to 30. However, in full candor, the court may probate or suspend any portion of that sentence.
And you are electing not to seek recidivist punishment for Mr. Mize because you've shared at least 3 felony convictions, the big one, aggravated sodomy, and then 2 not insignificant ones about failure to register. But I don't see a recidivist notice. You haven't mentioned that. So that's not something I can impose as any type of recidivist sentence. Is that correct?
I understand. I understand. And at this point, Your Honor, that is not the state's intention.
Okay. If Mr. Mize went to trial, is that something the state would explore?
Yes, Judge.
Okay. All right. Thank you. Ms. Roberts, could you share with me, please, the criminal history information you have for Mr. Mize?
I show a total of 18 cycles. I see those same 3 felony convictions: 2008 sodomy, 2015 failure to register as a sex offender, and then 2018 failure to register as a sex offender, along with terroristic threats and 2 counts of felony willful obstruction of a law enforcement officer. And his last arrest prior to this one was from December of 2022 out of Cobb County for a probation violation. The underlying was that 2018 conviction.
Okay, thank you. Ms. Tucson, is Mr. Mize currently on probation anywhere for anything?
He is currently on probation. in Cobb County for
Okay.
2 cases.
2 cases. Oh, is the ag sodomy from Cobb County?
That's correct.
Okay, because he's got the failure to register and then the underlying case.
The obstruction and terroristic threats is one.
Yeah.
And then yes, the one you just mentioned. So it's
Okay.
those 2 that's
Okay.
active.
Thank you. All right. Ms. Wood.
Thank you, Judge. We understand the serious nature of these types of charges. He was released from DOC last year, had issues getting on his feet. His only family in Georgia, and therefore the only stable housing that he would have, is in Cobb County. Cobb County has enacted a banishment against him. So that is part of his struggle. He was unhoused at the time of this offense. And he's actually been in custody, I believe, whatever that date was, they just mentioned for the Cobb County case, he's been in continuous custody. So he was produced here from Cobb County after he was violated on that probation.
Okay.
We're asking the court to consider a sentence of 5 to 6 months. He's been in custody since February 21st of this year, so 212 days. He is 46. He has an 11th grade education. He has worked in landscaping. He's also been gainfully employed as a box truck driver. We would just ask for the 5 to 6 months. He is indigent, so he would not be able to pay a fine. And that he understands, we went over that he has to register within 72 hours of any release, Judge.
Sure. So, Mr. Mize, it sounds like the stable place you could go to, a mom, an uncle, a brother, whatever it is, that's in a county you can't go to. That's the dilemma you're in. Is that correct?
Yes, sir.
Okay. I don't know if the personnel from the sheriff's office in Lowndes County, or probably not Cobb, but Fulton has explained, even if you don't have a stable residence, you still need to register. We do have a handful of folks on the registry who basically say I'm homeless. And then that may change the frequency with which you check in with the sheriff's office until you find stable housing. And stable could even mean I'm at a shelter, but then at least it's a fixed address. But that obligation is a heavy one, and it is exclusively on you. It's not the sheriff's office job to say, hey, we haven't heard from Mize in a while. Let's go check that location. If you are having to bounce from place to place because housing is difficult, each time you're in a new spot, you need to let the sheriff's office know that. Unless, as I said, if you are unhoused, you really don't have a place, you don't need to tell them, hey, I was under this bridge this day and over there, but you may need to be checking in with them more frequently. And I share that with you not to say, hey, this is easy, you should be able to do it. It's not easy, but it's an obligation that you have, and it's bitten you twice. This will be the 3rd time, and it's only going to escalate. I think, Ms. Marsh, the 5 years out of Cobb, because that's a more severe sentence than you're asking for, there was additionally the terroristic threats in the mix, et cetera. It wasn't just the status offense of failing to register. There was more to it.
That's correct.
Okay, all right, because this was, it was probation in Lowndes, 5 years all of a sudden in Cobb, and then you're coming back down, but this is purely a failure to register.
Correct, Judge.
Okay, all right. Mr. Mize, is there anything you want to share with me about this?
I mean, it would happen. I can't take that back.
Yep.
I did it. It happened. I should have made a little better choices, So only thing I asked for, I asked for a program. They wasn't able to find me one. So at the end of the day, I'll be back. I mean, if they let me go, I'm got to come back out here today.
Yeah.
Not today, but come transfer my probation back to Fulton County. I still got my job, so.
Which one? Landscaping, box
trucks.
Okay, and is that through a friend or?
It's some people, a warehouse in Fulton Industrial.
Okay. Well, Mr. Mize, I find there's a factual basis for your plea. You've acknowledged that you didn't do it, and you need to do it. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we discussed. Any questions about anything?
No. I mean, there's nothing much to say.
Yeah. Okay. I hear you. And voluntary just means no one's forcing you to enter this plea. You may feel like you're under a lot of pressure because it's go to trial, but no one has said you better plea or I'm going to hurt your family or anything like that.
No, sir.
Okay. I'm sentencing you under the Probation Options Management Act, which simply means that while you're on probation, if you have a small issue, you and probation will sort that out. But if it's a bigger one, any arrest for anything, that will come back to me. Ms. Wood, may my staff sign the indictment for you?
Yes, Judge.
Ms. Marsh?
Yes, Judge.
Mr. Mize, we're signing more documents electronically these days, just so we don't have to pass paper around. Is it okay if my staff signs your name to the indictment indicating your guilty plea?
Okay, yeah.
You all right with that?
Yeah,
It happens all the time.
I just had to look at my term.
Yeah, that's wise. Get her input. If she's saying, that judge is crazy, then you need to say, no, sir, I want to sign it myself. But all it is an electronic signature saying, yep, I pled guilty. You understand that there may be consequences for your probation in Cobb County. This guilty plea may cause Cobb County to say, you got to come back. We got to talk to you about it.
Yes, sir.
I don't control. If it was a Fulton case, we could deal with any possible revocation here and now. But it's a Cobb case. In fact, it's 2 Cobb cases. And so a judge in Cobb County may want to talk with you and a lawyer about your Cobb probation.
Yeah, I just came from there.
I know, but I just don't know if they revoked time.
No, they
for
reinstated my probation.
Okay. But was that in connection with your failure to register or not?
I asked my mother to call my Cobb attorney. I was trying to get him, but it was hard. He's in trial to get him to fax my sentencing paper for when I just got my probation reinstated. They gave me time served for probation for reinstating me and gave me time served for the violation, 65 days, time served for the violation and failure to register.
Okay. So then there likely will not be consequences for you out of Cobb County because they've already dealt with that. You got arrested for it. They gave you 65 days, whatever the math was, and they're moving on. Okay. All right. Mr. Mize, I am going to sentence you in this case to 5 years to serve 1 year with the balance probated. You'll get credit at a minimum for the 212 days you've been here. I don't determine the final calculation. It may well be that the 65 days you did as well will be credited to you. I'm not going to impose a fine. I think if and when you get back on your feet and you're working, that ought to go to paying for whatever you need to pay for, whether it's a room and house or whatever obligations you have. And you need to do it anyway, but I'm going to make it a special condition of your probation. You need to register within 72 hours of your release. Just make sure you do that. This sentence that I'm imposing is a little less than what Ms. Marsh asked for. I think she's asked for a reasonable sentence, given that this is your third. Is a little more than what your lawyer asked for. I don't think time served is sufficient. If this were your first, I could roll with that, but this is your third. And I don't know when you're going to figure it out, but you got to register. Here's where you are. You and Ms. Wood should talk about whether you want to accept this sentence, which is a parolable sentence. And you may not even be sent to the Department of Corrections because there's so little time left. Or you could say, you know what, I'm going to withdraw my plea and I want to go to trial. You heard what I heard, which is that the state may well look into recidivizing you, where they stack up your 3 prior felony convictions and say, Judge, should Mr. Mize be found guilty at trial, we're going to require you, and actually get to require me, to sentence Mr. Mize as a recidivist, in which case I have to sentence you to the max, which is 30 years. I can probate some of that, but any jail time I give you is non-parolable. So if after trial I said 30 to do 2, it's 2 to the door. It's not a parolable situation. And I share that with you not to say, oh, you'd be crazy to go to trial. That's not my call. That's your call. I just want you not to be surprised if the landscape looks a little bit different when you get to trial, if that is your decision. So I'm going to ask you and Ms. Wood to talk for a little bit about your 2 options right now. And then when you're ready to re-engage, come on out here.
Thank you, Judge.
You're very welcome. Ms. Rockwell, if you and Mr. Hardaway could turn your cameras on, we'll do our final position here. There's
Good
Ms.
morning,
Rockwell.
Judge.
Good morning.
Good morning.
Let's add you to the spotlight and add Mr. Hardaway. Excellent. Okay. Let's get on the record in position 11, 23 SC 187613, Antonius Hardaway, who is appearing virtually. His lawyer, Ms. Rockwell, is appearing virtually. We have Mr. Peoples right here. Mr. Peoples, have you provided all of the discovery in your possession?
Yes, Your Honor.
Ms. Rockwell, is there anything that you've found to be lacking in the state's discovery?
Not that I know of at this point, Judge.
Okay. Mr. Peoples, what is the state's offer to Mr. Hardaway?
Your Honor, the state's offer is 7 years probation, a weapons forfeiture, completion of an anger management course or a family violence intervention course, and no violent contact with the victim, and 80 hours of community service.
All right. Mr. Hardaway, are you able to hear us?
Yes, sir.
Were you able to hear that recommendation that the state would be making if you entered a plea?
Yes, sir.
Is that something you're interested in pursuing, or do you want your case to go to trial?
I'm not interested in pursuing.
Okay. Ms. Rockwell, anything more you want to get on the record?
Judge, that just that I did come to your courtroom this morning and I had a chance to speak with Mr. Peoples. My understanding, he's going to leave that open. I did indicate our position on the matter. Mr. Hardaway does know that today's the last day to move it with the right, easy for me to say, the right for him to withdraw. I did learn that Miss Christina Clark will be my next prosecutor to deal with. So having said that, Judge, he does want to stand by his not guilty plea. So that's kind of where we are.
Okay, so what we'll do, Mr. Hardaway, is move your case to the trial calendar. You are going to be on our November 8th trial calendar. You'll need to come to court for that one. No virtual appearances then. You and Ms. Rockwell will need to be here. And we'll figure out if yours is one of the cases that will get in front of a jury. You can always resolve your case short of a trial. The only thing that's changing after today is that you don't get to withdraw your plea if you don't like the sentence that you receive. Any questions about any of that?
No, sir.
Okay, I will see you on November 8th. Make sure you stay in touch with Ms. Rockwell. Ms. Rockwell, I hope you're doing well. Anything else on behalf of Mr. Hardaway?
No, Judge, just thank you so much for this platform. I was able to stick my head in your court, stay tuned in on my Zoom, ran to see Judge DeForest. I'm over here in Clayton County now, about to enter into a mental health court plea, and I've got Judge Cox on. So thank you. The lawyers, now that the doors are opening, we really, really, really appreciate you providing these platforms, Judge. And you know you have the best staff in the courthouse, right?
Do know that. I'm spoiled in that respect. All right. Thank you for that input.
Thank you so much.
Good feedback. Mr. Hardaway, I'll see you in person on November 8th, okay?
And Judge, if I may.
Hold on one second. Yes.
Just that the state will leave the offer open.
Okay. So the offer is open 9 a.m. You're going to want to be here in my courtroom, 8D. You'll get notice. Have you moved? You still live in the same place?
Yes, sir.
Okay. So you'll get something in the mail. More importantly, Ms. Rockwell's going to be blowing up your phone saying, don't be late, Hardaway. So you want to be here
I know she will.
9 o'clock on November 8th.
Okay.
All right. You two are free to go.
And Judge, I'm gonna steal your little saying where you said no squirt guns.
That's right. No squirt guns.
Thank you, Judge. May I be excused? Thank you so much.
And I believe that concludes my business. May I be excused as well?
You may. So what do we have? We're waiting on Mr. Mize, and I think that's it. You're still here. You're just hanging?
Well, I actually had it sealed, so I could have left a while ago. I had the second case, but I just didn't see her working.
Okay. Well, I feel like the study hall, Mr. Abate often stays in here, I think, because he's off people's radar. Like, you can go. It's like, no, I'm getting work done. This is good. All right. Well, it's always nice to have folks around.
Thank you, see you this afternoon.
Yeah, so we've got probation revocation calendar this afternoon. Are you handling all three?
I think so. I was gonna bother Attorney Willingham, but,
You guys sort that out. As long as we've got a happy prosecutor in here, we'll be good to go.
or even maybe a horse.
Yeah.
Thank you.
All right.
Thank you, Judge.
See ya.
I'm going to sneak out too, but I'll see you at 1:30.
Yes, ma'am. So you have one or more of them?
Yes. Mr. Adams has the first one and I have the rest.
Okay. All right. Oh, hey, Miss Feely. Did she get away?
Judge,
Yes.
I think Miss Clark is on the line and she's trying to get your attention.
Oh, okay. Oh my gosh. Is this the Christiana Clark? Holy moly. There she is. Hey.
Hey, how are you doing?
I'm well. You don't want to actually come into 8D?
I do plan on coming, Your Honor.
Okay.
I was observing this morning and I was trying to transition from my other room. So that's why I wasn't there live in person.
Got it. So you're with Judge Eaton right now?
Yes, Your Honor.
When does that role close out for you?
This week.
This week. Okay. So it's an awkward time for the transition, and I trust Mr. Peoples has been sharing this with you, but tomorrow we call a trial calendar with, I don't know how many cases on it, 25 cases, something like that. And a bunch of them say Dion Peoples on them. And so I don't know if you can be here tomorrow or if he is just going to commit you to being ready to try all those cases or what. But I want to make sure that he had shared with you the fact that starting next week, in theory, we could be in trial for a few weeks. And if we are, there might be a few of the cases that were his and are becoming yours that would be going to trial.
Yes, Your Honor, I understand that, and I'll be ready to go. And I'll be there tomorrow as well.
Fantastic. Well, we look forward to working with you. If you want to come by Chambers at some point to meet Ms. Nelson, the actual brains of the operation, or with me or both of us, we'd be happy to chat with you and disprove all the bad things Mr. Peoples has been saying about life in 8D.
Okay, Your Honor, yes, I will reach out for a meeting in person, but I'll in court.
Sounds good. Well, we'll see you tomorrow.
Thank you. All right.
Bye-bye. Hey, Ms. Feely, I didn't mean to reel you back in like that, other than there's been this traffic going back and forth about a continuance on the Saye O'Neill stuff. And you've got the co-defendant. You may have O'Neill. I don't remember who has Carlisle and who has O'Neill. Mr. Shepard is consenting to the continuance. And I just wanted to get your perspective on that too.
So I have Carlisle.
Okay.
And it is, my motion was just a motion to sever parties. So
Okay.
it doesn't.
We can argue that whenever. What was the other piece? Was it all the substantive ones?
Yes, I think Mr. O'Neill's attorney filed a motion to suppress ID maybe.
Yes. Well, he filed a million motions, but there was something we were going to go forward with and we couldn't. I don't remember why we couldn't with O'Neill and Carlisle before. I know we talked about some motions that didn't require witnesses, but you don't oppose this continuance, or you do, or you're just going to stand mute. I just wanted to get your input on it so that I can get responses to folks because it looks like it's for Thursday.
Yes, and I think it's the only thing I have Thursday morning. So and like you said, we could have a motion to sever parties.
I guess we could go forward with that.
Right.
Okay. All right. Let me look at what is teed up for it and I'll get everyone a response. in time.
And I don't feel strongly about the continuance, but
Okay, thank you. All right, well, if you try to leave now, I promise I won't send Deputy Gordon after you. It was just that question. So in about a minute, let's bring them back, please. So what's your deal? You were not here this morning. You're down in what? Deidre said she was pitching a fit. Like, I'm getting Gordon back up here. She go to the colonel, say, where's the guy?
I was at one, well, it don't come up till 3 o'clock. So I was at one meeting and then most of us about what see.
What's not till 3 o'clock?
We'll see who starts.
Till 3? Huh. Interesting. So that's why we had Partridge in here too. He had some free time. Interesting.
I think it's just 4 jurors.
Okay. So you're free until then, and then you got to be there. What about tomorrow? Tomorrow is the big one. I don't want to have these rookies who are taking people back downstairs. Okay. I know. You do what you're told.
It beat to like 6:30 yesterday.
Really?
All
Motions? Motions about jurors or other motions?
but evidence and stuff like that.
Oh, no juror stuff.
The juror, but we gonna get to him was too late. So he rescheduled the juror.
I went by just to bug you, but it just didn't seem worth it to try to poke my head in that court. I was checking on Judge Emerson to see where they were, and they're only going to have one trial over the 2 weeks. This trial they're doing is a beast, and it's going to go at least into tomorrow. So we had one plea, 2 null process in this trial, so it was not a real productive calendar for him. So I did look in there, and then on my way back, I tried to open the door to 1C, and it was locked, and a couple gray shirt, like, it's like, where do they have you just sitting in there? Don't touch anyone. Don't hand anyone anything. Don't accept anything from anyone. Don't wink at them.
Camera can't do
It's like he was never there.
that.
That's funny. So this morning when I was pulling in, Lattimore was part of the 4 guys standing out there. And he must have told Sarge that I wore a Packers jersey, because then I'm at the gate that stops you. It's going beep, beep, beep. Sarge comes from, I'm like, hey, Judge. I'm like, what? And he sticks his big old hand in there, go Pack, go. Like, you too?
He went to the game.
Hmm?
He actually went to the game.
Oh, he did?
So I called him, like, y'all let me down. You see, let me down.
Yeah.
Each time we the weapons at the game.
Yeah, it was not a pretty game for the poor Packers. I was there with the clerk, and we had this field level box literally on the field. She was on the Jumbotron like 10 times. And she made me sit 2 rows behind her so the Packers jersey wouldn't be on the camera.
Cleared it out.
All right, let's get back on the record in Mr. Mize's case. Mr. Mize has been spending some time with Ms. Wood to talk about his options. I appreciate that he's not particularly enthusiastic about either of them, but I need to know, Ms. Wood, if Mr. Mize wants to go forward with his plea or withdraw the plea and have us move the case to the trial calendar. And before I do that, I guess we should add, I guess if he's maintaining his plea, I don't need to get this last bit of information from Ms. Marsh. I was just going to ask her if that offer stays open or if it's gone because of the recidivist angle. But is Mr. Mize wanting to go forward with the plea?
Well, Judge, he has a concern about whether Department of Corrections is going to give him time or credit for the time that he served in Cobb before I got here.
Yep.
I believe he should. I believe he's entitled to that since it happened after this offense. But I just never want to make that promise.
It's a fair question. Let me tell you what I learned recently, Mr. Mize. I've now been doing this for, I think this is year 11, at least 10 years. And I learned something new last week. Historically, I would put on final dispositions, your sentence, hey, you need to give Mr. Mize credit for this and this and this. That's actually legal error on my part if it's going to the Department of Corrections. I can give you credit that you have directly served 212 days because I got eyes on that. You were here, you've been booked in, and so you'll get credit for that. But what we're supposed to do is check the box that says as determined by the custodian, which would be the sheriff of Fulton County is going to send some information, and you may tell DOC, hey, you need to look at the Cobb dates, and you're able to advocate for yourself. And in fact, you can bring a habeas challenge against the Department of Corrections if they're not giving you credit. But what the Court of Appeals has now said repeatedly, I didn't know this, to trial court judges is don't do the Department of Corrections job. They determine what you get credit for and what you don't. I don't do that. And if I were to tell them, it is merely a recommendation. And the higher courts have said, trial judges, you need to stay out of that. You will say what the sentence is. And what I have said is 5 years to serve 1 year with the balance probated, and you need to register within 72 hours. Whether you get credit for just the 212 or 212 plus 65 maybe additional time, that is a decision for the Department of Corrections. Now, the woman standing next to you has a whole lot of experience with what Department of Corrections does because her clients say, yeah, I got it or I didn't get it. But neither she nor I has that crystal ball that can say, I guarantee you, or I promise you, or I swear that. She can give you a likelihood. Same with parole. You're going to get paroled. Will you get paroled right away? You don't think you'll get paroled?
I know I
Okay.
won't.
Okay, well, I don't know why you think that, but this is a parole eligible offense because the state hasn't recidivized you like it sounds like they will if you go to trial. So I would like to give you more clarity. That's just peace of mind. But I can't, and sounds like Ms. Wood has correctly framed it. She thinks you likely will, but she can't guarantee it. You need to figure out what you're going to do. If you're not going to get credit for it, you're also not going to get credit for it if you go to trial and get clobbered by the jury. So either you're getting the 65 or you're not. The question is, how much are you adding to it? I'm saying it's a year. If you go to trial, it may be a whole different ball of wax, but who knows? You also may be found not guilty by a jury. What you need to tell me is whether you want to go with the known 5-1, or you want to roll the dice at trial to see what happens, guilty, not guilty. And if it's guilty, Ms. Marcia said she intends to recidivize you so that whatever sentence I give you, you don't need to worry about parole. That one's off the table. So with that, Mr. Mize, do you want to go forward with your plea, or do you want to withdraw your plea and then we'll get you in here for a trial?
Wow. Respectfully, I wasn't coming here today thinking about no plea. I came here today because your word was last month that I'm going to bring you back on a bond reduction. So all this is a surprise.
So you're surprising me. I already did the bond reduction.
No, I mean, you told me you gave me a bond.
Yeah.
25,000. You said I will have Ms. Woods file paperwork to get you a bond reduction. You'll be back next month.
Well, I don't make Ms. Wood do anything.
No.
So
I'm just saying.
Not my role.
Yeah. So coming today, thinking I was here for one thing, now I'm here on a final plea. Okay, I will take the 5-1. It's just that I've been locked up since October last year.
Okay.
And, I was just like, okay.
Well, that was real close to a year. And so if you get credit for all that, then what remains of your sentence is real short. The most it would be, and I don't mean to suggest a day in jail is a short time, but the most it would be 153 days, because that's 365 minus 212. That's the most it would be. The least it would be is the sheriff's people look at all these numbers and say, get them out. We got rapists and murderers in jail. You have a serious conviction, but that's from way back when, and you're in on a registry violation. So you may not ever darken the doors at Jackson because of what remains. But again, all that is surmisal as to what's going to happen. But I heard you say you're going to take it.
Yeah, well, I was planning on it. It's just that I have 9 years left on paper. And I'm not quite sure that if I take this plea and go to prison, that Carl won't bring me back and send me back to prison.
So you told me that Cobb has already
reinstated my probation.
Right. And if those 65 days were connected with your arrest, whenever you got arrested on this case, they don't get 2 bites at that. Okay. Now that there's a conviction, it's the same conduct. Your lawyer would prevent that from happening. That would be a legal error. Okay. Now, I will tell you this, if you get out in whether it's a week or it's 3 months, you get out and you don't register and charges are brought, Cobb is going to drop a bunch of bricks on you. You're fourth. So that's something that my crystal ball tells me would likely happen.
Mm-hmm.
All right. Well, I wish you the best in finding your way when you get out. Make sure you register wherever it is you're staying, and we'll take it from there. We do. Right. Ms. Tucson, any reporting instructions? What do you need to tell Mr. Mize?
Well, as far as right now goes, in Portal, it's showing that he is being supervised by Cobb, but he will be having this docket uploaded to Portal, so he will still need to report. If he cannot go to Cobb, he would need to report to Fulton, and call Cobb as well and let them know that you have been released from custody and report to Fulton County. But do that within 48 hours of release.
So are they gonna be random?
Yes. And I'm gonna give you this so you'll have it, okay? Thank you, Judge.
You bet. Okay, thank you, everyone. Ms. Tucson, if you could rejoin us at 1:30, we've got our revocation calendar. And if you don't mind getting to Ms. Nelson, the time remaining for the 3 defendants on that calendar, she can get that to me and we'll be good to go.
No problem. I will send that over now. I have the calendar right here.
Thank you.
No problem.
We're good. Okay. Good afternoon, everyone. Ms. Rivers, can you hear us? Excuse me.
Yes, Judge, I can.
Great, we're connected. We have a 3-defendant probation revocation calendar. And I think you had said, Ms. Feely, that you believed Ed Adams was handling position 1?
Yes.
All right, I do not see him online or in person, so we'll circle back to that. Do you have a preference whether we bring Mr. Shipman out or Mr. Alexander?
No preference.
Okay, well, let's just go in the order it's published. Let's bring Mr. Shipman out, please. All right, let's get on the record in position 2. It's 18 SC 158587. It's State versus Julian Shipman. Mr. Shipman is here in court. Good afternoon, sir.
Hey, how you doing, sir?
I'm all right. How are you doing?
I'm fine.
Good. He's here with Ms. Feely, who is representing him for purposes of this revocation. We have Mr. Peoples here, unable to convince Ms. Willingham, apparently, to cover the calendar. And Mr. Shipman, I have a petition, I guess it's a warrant, that I signed for your arrest in connection with an alleged probation violation. And the allegation is that you violated your probation in this case from 2018 by committing 2 new offenses. One is battery and the other is riot in a penal institution, which is something that probably happened out at the Fulton County Jail. That supposedly happened in May of this year. I signed the warrant in July of this year. I see from my calendar that you have 2 open cases with Judge Carnesale, cases that have been indicted. You've got just under 11 months remaining in your probation on this case. Ms. Feely, is Mr. Shipman admitting for the purposes of this hearing these allegations?
Yeah.
Okay. And what can you tell me about the 2 open cases with Judge Carnes? I can look them up, but if you already know, are they something had Mr. Shipman in jail in May of this year? And I'm assuming it's one of Judge Carnesale's cases. I'm happy to look them up if you haven't.
I believe they're both ag assaults, Your Honor.
And when I went to see Mr. Shipman at the jail, he was a little bit confused because he thought he had already dealt with probation back in February. But he just happened to have this loose end to tie up that we were hoping to resolve today.
Okay. When you say he had dealt with it, what happened back in February?
I think he had some period revoked.
You reinstated me on the Carnesale charge.
Okay.
The reason I'm locked up.
Well, got it. So you and I did business earlier this year, and I found that it was a violation of your probation to have engaged in one of the reasons why I guess you're in front of Judge Carnesale.
Correct.
Got it. That's older conduct. You demanded a speedy trial.
Yeah. One of them from 2021.
Okay.
And one is the reason I've been incarcerated this time around. And you reinstated me.
Okay. All entirely possible. Let me look up the other case here. I just need to make sure that neither of the cases with Judge Carnesale is about battery and riot in the penal institution, and neither one is those. So we're together again because there's a new allegation, not the Carnesale charges, but this. Do you know, is there a CP number associated with this?
That's what I'm looking for right now, Your Honor.
Okay. I don't know. I don't think there'd be a new booking number because Mr. Shipman was already in jail when these things allegedly happened.
I believe it's 23 CP 216632.
I'm seeing 20, oh, well, those are closed. Hang on.
You said 216612?
Let me just double check.
That's someone different.
My writing. Okay.
I'm seeing that right in a penal institution, but it's showing closed on.
We got it throughout.
Okay, but what's the CP number?
23 CP 218976. Looks like it would have been in.
Whoa, it's a lot of people. Okay. Battery and riot, and the DA declined to prosecute. All the way at the end.
I'm seeing the decline as well.
Yeah. Okay. Got it. Okay, that doesn't mean we can't go forward today. There are different things, different standards, et cetera. Ms. Feely, what was your recommendation as to what we do with Mr. Shipman in light of both the nature of these charges and what we've discovered by finding that CP number, that the DA's office isn't going to be prosecuting Mr. Shipman for his possible involvement in a some type of affray at the jail?
Yes, sure. And my understanding is that was the only allegation of this one. So we would ask the court to revoke maybe 60 days and reinstate. He's got obviously other things to deal with.
Do you have a bond, Mr. Shipman, in either of your Judge Carnesale cases that you know of? It's not a quiz. I can look it up. I was wondering if you knew.
I had one bond for one in 2021. This one, no, I got a bond hearing.
Okay.
I don't have no bond. I never went for a bond hearing. Soon I got indicted, I filed a speedy trial.
Got it. And when you say you filed a speedy trial, you did or your lawyer did?
I did.
You did. Okay. All right. Well, you may want to coordinate some with your lawyer, but I see so you've been in since basically like Thanksgiving on the newer of the two ag assaults.
Yes.
Got it. And there was a bond order right about Thanksgiving that said no bond from Judge Hughes. And then you're right, you have no bond. Okay. But you think you're coming up for a bond hearing, or you're hoping you do?
My lawyer filed one, I think this morning or yesterday.
Okay. It just hasn't hit the docket yet. You're on a trial calendar for like 2 weeks from now.
Yes, October the 5th. They it's a if you go look, they filed to stop the trial.
Who filed to stop the trial?
Attorney Rhonda Hill
Okay.
is under the case now.
Okay.
Ms. Carnesale says she's going to adopt the she just needed in paperwork.
Okay. All right. Mr. Peoples, what's the state's recommendation?
Your Honor, the state's recommendation would be to revoke 320 days and return to probation.
So if I revoked 320 days, I think that would leave about 8 days on probation.
Oh, it's closing out.
He has 10 months and 28 days left. So if I revoked 300 days, that'd be 10 months. 320 days would be 10 months and 20 days. So that would leave 8 days. So if I were to do something like that, it seems like I ought to just close out the case.
Then that would be the state would adopt that, Your Honor.
Okay, all right. Ms. Toussaint, is there anything else rattling around for Mr. Shipman, or it's just this 2018 case? He's not on probation in anything else?
From what I see here in the system, this is the only case that he is on probation for.
Okay, all right. Let me look at the warrant again. May 26. 5 months. So, Mr. Shipman, I am going to revoke 6 months of your probation, and I will terminate your case following that. You will get credit from the date of the alleged incident, and you won't need to worry about this 2018 case anymore. You'll have your 2 cases with Judge Carnesale, and that'll be the business that you need to navigate. But that'll close this case out. Any questions about that, Ms. Feely?
I think he does have some questions about the time served. It's the court's intention that he's finished the jail portion of that revocation?
No, so he could not get credit for time served any earlier than May 26th. So that's when the clock would start. If you push that out 6 months, assuming he doesn't get 2 for 1, and I'll be silent on that, then that will go to like the middle of November, so a couple months more. But it closes this case out. And he currently is in a no bond status on one of his cases anyway. So it's not 6 months from today, it's 6 months from May 26th. And then the other part that's important is whenever the sheriff decides he's done with the revocation piece, we're closing this case out. So you're not, just as an example, if you entered a plea in one of your Judge Carnesale cases, that's not something that would mess with this probation. I'm revoking you once and for all, 6 months, and you're done with this case from 2018, which was a marijuana and one other drug case.
Yes,
So whatever happens with the Carnesale cases is sort of a clean slate. And whatever you and your lawyer or lawyers negotiate with the prosecutor there, you don't need to worry about, oh, we got to deal with the probation in this other case.
Yes, sir.
Okay, Mr. Peoples, anything else?
Nothing further.
All right. Did you have other questions, Mr. Shipman, or did I answer them?
You answered it, sir.
Okay.
So 2 for 1 come from the jail, like is they
Their decision.
discretion?
I can put on there no 2 for 1. I'm not going to put it on this one.
Sure.
All right.
Okay, thank you, sir.
You bet. Good luck with everything.
You too, have a nice day.
Judge, I just want to confirm on that one.
Yes, ma'am.
What I have in the system is the date of him going into custody is November 24th, 2022.
Right. But the allegations to which he is stipulating involve a situation from May 26th, 2023. So he gets credit from May 26th, 2023.
May 26th, 2023. Okay.
Yes, ma'am.
And then suspending the balance, revoke 6 months, suspending the balance.
Not suspending, terminating, because I don't want, there won't be much of a balance left, but should Mr. Shipman work out his cases with Judge Carnesale, I don't want there to be like, oh, but he's got a little tail left on the 18 SC case.
Okay. I just wanted to confirm that. Thank
Yep.
you.
All right. So if we could have Mr. Alexander, and is his name backwards in the system, or he is actually last name Alexander?
I believe the last name is Alexander, but it's
Okay.
in both ways and not a C.
Yeah, of course it is. All right, we have Mr. Alexander here. Good afternoon, sir.
How you doing, sir?
Good to see you again.
Yes, McBurney.
So we've got 3 cases. It's positions 3 through 5. And on each of the 3, Mr. Alexander has a little over 6.5 years remaining on probation. I'm going to call up the warrants that I signed. Let's take a look. So in July of this year, I signed warrants in each of the 3 cases that Mr. Stevenson took a plea in kind of recently. And the allegation is that there was a violation of criminal law, failure to report. What do we have here? The allegation is 1, Mr. Alexander did not report to probation after he was sentenced. 2, he didn't complete the Sober Living of America program, about which I heard a great deal. I was told this is what's going to be good for Mr. Alexander. He's going to do it. And then 3, in late May of this year, Mr. Alexander got arrested for another shoplifting. And all 3 of his cases were shoplifting cases. So, Ms. Feely, is Mr. Alexander admitting to these allegations? And what's the status, if you know, of the unindicted, if it's unindicted, shoplifting?
So importantly, that was a warrant that predated, it's not new, just so we don't, it is not, he got out of jail and committed a shoplifting, I see.
It says here that the shoplifting was on May 20th, which would have been after he was released to probation.
I think it was a warrant that had been rattling around that hit.
Okay, so maybe what it should read is that on May 20th, he was arrested for shoplifting, but the shoplifting was an old one. Why don't you look for that? I can take care. We have some indictments here I need to ratify. Put them on their way.
All right.
Hello again.
Keep up, man.
Thank you so much.
78.
Yeah, got a little way to it.
Yeah.
Put that mobile in there.
I got it. In June 14th.
Uh-oh.
On Rice Street.
The one naming me? That's always a good outcome.
And to the program. Yeah.
Gosh, it's a lot of cases.
And I reported to
You're gonna work Thursday, Friday just as hard, or they get a
No, it'll be the same time, sir.
more relaxing?
Friday may be a little easier, Thursday will look like this.
There you go. Can you carry that? You want a cart? You got it?
Thank you so much.
You bet.
Thank you.
Take care. All right, were you able to, I wasn't looking things up. Were you able to find anything, Ms. Feely?
So, yes, there's another booking number that I'm pulling up now. I'll print out all this.
I had maxed out, but I had a hold in East Point. And I went to East Point and they raised it back to a felony. Then they sent me back to Rice Street. That might be it right there.
He believes he was in jail at the time that the warrant says.
Yeah, which one? Is it this one?
So I've got a booked in of May 27th, booking number 2308326, theft by shoplifting.
08326.
Yes, and that citation for shoplifting was actually from East Point on July 22nd of 2020.
Huh.
figured out what the
couldn't get that booking number to come up. I don't understand. Okay, so tell me what you think is going on. I'm confused. There was not a shoplifting in May of this year?
There was not. He was booked in on the 2020 citation at that time. And when I spoke with him at the jail last week, I had all this printed out. I don't know why I didn't grab it, but it is under that booking number 2308326. It's in his intake paperwork that shows the East Point citation. So that would have predated this probation by years.
Who's Gladys Alexander?
That's my mother. Can I explain what happened about that shoplifting charge, Your Honor?
In a little bit. I promise I'll hear from you.
All right.
So the current booking number is for the 3 probation warrants. I've got that one. I don't understand why it won't pull up the other booking number.
It actually is quite searchable by his name, either way you put it. And I believe it's the second most recent booking.
Well, but I have the booking number, and when I type it in, it says no such booking number. So I can't see any of the records in it.
I just saw the new stuff. The CP burglary.
Did you get it?
Yeah, but if I put in the booking number, it says no such, that's the booking number.
Hit that.
Oh, released jailings. Oh. Okay, got it. Thank you so much. I don't move much on the jail side of things, as it shows. Perfect. Okay. So it was a ticket from July of 2020. So it's another shoplifting, but it predates his sentences as well as his probation, and somehow it caught up with him. Okay, it's a Walmart in East Point. So familiar setting. All right, so then really what we're dealing with is an allegation that you walked away from probation and didn't do sober living, even though that's what you said you were going to do. So why don't I promise you're going to get a chance. I will hear from you. I want to hear from Ms. Feely first. It's no apology. It's all good. Ms. Feely, what's going on with Mr. Alexander?
So he was transported via a transport order to Sober Living America, and he tells me that they needed the money up front, the $362, which he didn't have because he was just released from jail. So at that point, he his family picked him up. He tells me he did report to probation
Yeah,
until
the next day.
around June.
June 15th.
And the address, his mom put him out. And so he was unhoused for a period of time because she incorrectly thought he had taken her
Yeah.
iPad, but then she found the iPad somewhere else in the house and she let him back in. But I think that really tripped him up with probation too. But he does still stay at the address that probation has. So we're asking the court to consider he is not picking up new charges, including new shopliftings. And this is a technical, of course, pretty serious one, but a technical violation. So we're asking the court to sentence him to the time he's served.
So 682 Catherine Street is Gladys Alexander's house?
Yes, sir.
And she has unkicked you out because she found her iPad?
Yeah, because she thought I was that same addict from years ago. And, I would, put in the act like I never took her. So knowing I did, that was back then, but I've changed now. I ain't been doing nothing. So she actually found it. I was actually innocent of it, but she actually found it a week later because she forgot she misplaced inside the other car. So, I had spoke to her on the phone. She, she apologized. She said that, since I'm locked up for probation, if there's a fee I gotta pay, then, she'll pay it, whatever, and she'll let me back in.
Does your mother work?
No, she retired.
Okay. She's bonding you out left, right, and center. Where does she get all that money?
Bonding me out?
Well, she's just always the name that's listed.
Oh, yeah. Well, she don't have no lot of money like that. She just get a check a month from retirement check. And she's currently working on a house that she's been having for like years. She's trying to fix it up and, rent the rooms right now. That's basically the only other, income she's trying to get right now, besides her retirement check. But she ain't got no money like that, But no. But she was letting me know that I had some fees, probation fees, like I wanted to straighten. And she said she's gonna come through with me, you know what I'm saying? But
okay, I'm less worried about the probation fees. I'm looking at your pleas from the 3 cases. And I can't remember why we didn't do drug court. Why did we not do drug court?
I don't remember either.
Because I already have been through drug court 2 times already. I don't know if I can go back there again.
Did you go through drug court and graduate from drug court,
I
or?
didn't graduate.
And was it drug court in Fulton County?
Yeah,
Did you get terminated?
I got terminated.
Okay.
You was, matter of fact, you was my judge for that last one, I believe, back in 2017. If I'm not mistaken. See, the thing is, right now, my mind was trying to really focus on going to that PAD program.
Is PATH different from Sober Living of America, or that's the same thing?
It's basically, it's different from, matter of fact, they got this little program thing, shelter, that's like right next to the, you see, what I was gonna do was gonna get out because I heard of probation. I was gonna talk to my probation officer and she could actually put me in there because
Put you in where?
Inside the PAD program, because they hooked up with them. And, my living situation, my mother, it's just like, I don't feel too leery about living with her again. But I was gonna stay there temporarily and talk to my probation officer and have them transfer me over there to that PAD program because I've seen a lot of successful people end up successful in the PAD program. So
what is it that you think the PATH program is?
the PAD program, well, really, they help addicts with their treatment, especially the housing situation. I need housing situation. That's what I'm big at right now.
What's wrong with your mother's place? Why are you worried about being there?
Because see, I hate to go through what I did with her before. Like, she ended up losing something, then all of a sudden she blamed. I'm just tired of going through that, But right now, even though it's all right now, but still though, I'm still worried about the future about it. You know what I'm saying? So I'm just being real with the situation. So I would like to be like somewhere where I can really focus totally on me and my living situation and everything else that come with that.
So Ms. Feely, I'm not inclined to revoked to time served. It is not a particularly big number yet. I'm much more interested in getting Mr. Alexander into some program like sober living, but maybe not one that says, give me $350 when you walk through the front door, because Mr. Alexander's not ever going to have that on day one. He might earn it later, but he doesn't start out with it. My inclination is to let Ms. Ross look for opportunities, whether it's the PATH program or who knows what. But I'm not interested in revoking to release to hope that Mr. Alexander navigates it himself. Hold on. I would want to have Mr. Alexander released into a program, which I thought we did with sober living, but maybe the disconnect there was this entrance fee that they were charging. But based on Mr. Alexander's own words, I don't think returning him to the Catherine Street address is a great plan. And while I appreciate his commitment to sobriety, I'm not going to rely on him to find a program. I would like it found in advance and him accepted in advance. Plan B would be to revoke Mr. Alexander to RSAT, but I'm guessing that's not what he wants, given the wait period and the fact that RSAT isn't something that he can take a break from. So I think giving Ms. Ross a chance to look for some options might make sense.
I'm emailing her now.
Okay. Mr. Alexander, you've already shared with me some helpful stuff in talking about your mom and that living situation. Is there anything else you wanted me to understand?
Yeah, I mean, I'm saying like, right now we have no problem. I'm just saying though, like, cause I'm straight when I get back out there with her again. I mean, I haven't really committed no other crime like that. You know what I'm saying? So it's like, I just want to come back to her, stay there, cause I have no problem. She give me everything that I, want. You know what I'm saying? I got a good family.
Tell me when you say you come back to work, what's your job?
My job is warehouse work.
Okay.
Yeah, I want to do the warehouse work, get my job done. I want to save some money and get my own place. That's basically all I want to do. I have no problem living with my mother. It's just that one little incident, even though it caused little negative energy, but the energy is back positive between me and her.
I'm glad you guys are sharing positive energy.
Yeah.
And hopefully that will continue. I need to know there's more structure out there than mom's positive energy when you get out. So I'm going to give Ms. Ross a chance to meet with you and to look at her resource network to see whether it's Georgia Works or PATH. I'm not going to say, oh, that's a bad program, but it needs to be a program, one that we deliver you to, not that you go to if you get around to it, that kind of thing. Because like I said, the fallback would be something like RSAT. But it doesn't sound like that's something you'd be real. I don't know that you'd have a lot of positive energy about RSAT. Okay. All right. Mr. Peoples, anything you want to add?
No, Your Honor.
Okay. So what we're going to do, Mr. Alexander, is bring you back here after you and Ms. Ross have had a chance to talk and she's had a chance to look at, like I said, her resource network to say, what's a program that's going to fit your unique situation? There's certain things you don't need support for. And there's certain things, addiction treatment, whatnot, maybe basic housing preliminarily, where you do need support. And she will talk with you and talk with some of those service providers and then meet with Ms. Feely. And Ms. Feely will say, well, good, we've got a plan. We want to bring it back here for you to consider. I'm happy to hear that the warrant is accurate in the sense that in May, you in fact did get arrested for shoplifting, but it was for something that happened 3 years ago at a Walmart in East Point. Clearly Walmart's an issue. I didn't realize till I reread it. That's one of the special conditions of your probation is that you no longer get to shop at Walmart stores. That is, you can go to Target, but no Walmart's for you. But this East Point arrest was from that phase of your life. Okay. So we'll bring you back here soon. Ms. Ross will meet with you and we will make a plan. Okay.
Is this ain't gonna take months, is it?
It will not take months. All of this will be much shorter than the wait to get into RSAT.
All right.
Okay. Thank you, everyone. So if people don't mind, not Ms. Feely, you don't need to stick around, but Mr. Peoples, Ms. Nelson is doing a APB for Ed Adams. Worst case scenario, we'll just bring him out and I'll say, I don't know where your lawyer is.
Understood, Your Honor.
I'm hoping that,
Your Honor, if I may.
We've got a defense attorney right here. Go for it.
For tomorrow, if possible, my son's birthday is tomorrow.
Uh-oh, how old is he turning?
2.
2.
So,
it's a big one.
Yeah, if I could take a couple of my pleas early on, as many as possible early.
So the only priority I'm given is Ricky Wolf, because there's a speedy trial demand. Once that goes away, anything. Hey, are you Mr. Rogers? Okay, we are looking for Mr. Adams. So you're welcome to take a seat. We're gonna give him a few more minutes. If we can't track him down, then we need to figure out when he can rejoin us so that we can handle your probation revocation. Okay?
Yes, sir.
I know we had a conversation about it. It was about a month ago.
Yes, sir.
I know you've got a couple cases with Judge Schwal and maybe one new one. But we can't do this without Mr. Adams. So they're looking for him.
So, may I tell you something though, sir? It's really important.
So if it's not about the facts of your case, I'm happy to listen to you. Although you need to know the person sitting next to you is not your lawyer. She's not going to be able to say like, oh, don't say that. So as long as you're not talking about the facts of your case.
I'm not.
Okay.
I just lost a sister and I plan on losing my mom. My mom just had a heart attack in the hospital and you can reach out to them. I lost my sister. She got hit by a car last month. And I just trying not to lose my mama due to the fact that my sister passed away and I'm not there because I'm with her caregiver and I'm not there. My mom had diabetes and she just had a heart attack and she's in the hospital right now. And at the jail we had video visits, so I seen her in the hospital be on a video visit.
Yeah.
But she just really hoping I can get my probation reinstated so I can get my bond out. She gonna use her money to bond me out. She get a check on the 1st and the 3rd. She gonna use her money to bond me out if I can get a bond. But
do you have bonds in the Judge Schwal cases?
Yes, he reinstated my bond already.
Okay. And then what about the unindicted case?
I'll go to court next week for that.
Okay, so right now you don't have a bond, but next week there'll be a discussion about it?
It'll been 4 months. And then my public defender, she came, I don't have a paid lawyer for that case. She came and said that after the 120 days, I do to mandatory bond.
Yep.
She said she gonna give me a guaranteed bond. So I'll be able to pay it. I just have to get this probation hold lifted.
Okay, well, worst case scenario, if you do line up all those bonds and we haven't connected, then we definitely need to connect. I mean, right now I could say, time served, you're still stuck because you don't have a bond in that. But I see the motion that your lawyer filed and you've got a preliminary hearing scheduled in about a month, but you're saying you'll hit 90 days before then?
No, I've been locked up 120 days.
Oh, so you're entitled to a bond.
Yes.
Got it. Which is why your lawyer filed this motion. What does it say?
And I have the affidavits. They written and notarized for the cases who the cases for, where they put accusations on me, but the people.
Okay, but now you're talking about that. That's fine. That's the kind of thing for Mr. Adams or for Ms. Carter, the lawyer who's helping you with your unindicted case. Yeah, she says all the right stuff. It's been more than 90 days. So that just needs to get in front of a judge. Okay. My staff is unable to contact Mr. Adams right now. My guess is he's in court.
Is it possible that I can go further with a public defender?
Not today. We would need to get a green light from Mr. Adams. He's your lawyer of record.
Can't reach him. He never came to talk to me. Never. Like, I don't pay him. And
You said you did pay him.
I did.
Yeah, so he either needs to say, here's your money back and come off the case, or he needs to step up. It was here last time, I mean, when we had the conversation, but I can't shift lawyers around for you like that. Now, it may be that your family shows up at his office and says, this didn't work out, give us the money back. But for now, he's your lawyer, and that's who I need to be dealing with.
Nobody pull up on my mom in the hospital. That's all I got.
Okay, well, it didn't necessarily need to be mom, and it could be someone associated with you, but
If it helps at all, I could make copies of these documents and email them to Mr. Adams. So that way, when he next appears, he'll at
Yes,
least
ma'am.
have this stuff. And I can.
so Mr. Adams doesn't have those things. Okay, all right. Do you want to make a copy of them here?
I'll go down to the fifth floor. office and
Okay,
just-
you got that space? Okay. All right, we'll keep you up here till you can get those back.
Excuse me, can I ask you a question? Do you know when my court date for my preliminary hearing?
For your what? Your preliminary hearing date is October 24th. But that's a worst case scenario. You'll have it then. Your lawyer's already filed the bond motion, which isn't for a prelim. That's, hey, it's been 90 days. And so she's going to try to get you in front of a magistrate before then, because that's a month out. And you're already at whatever you told me.
5 months.
Yeah. And it's not like your charge is murder or anything. So there ought to be a judge who is looking at setting, a bond.
So I would be in before then?
Hold on one second. So someone set a bond for you that is signature or unsecured judicial release, basically a signature bond on 2 counts and no bond on the other counts. I've never seen one like that. So you have a bond, it's just no bond for 2, and then a signature bond for the other 2 charges.
So what, do you know what I don't have a bond on?
Yeah, on the drugs and the drugs, but you do have a bond, a signature bond on apparently you were jaywalking. These are allegations and some obstruction. It's misdemeanor obstruction. So you gave a fake name or you ran or something is the allegation. Most of all, you need to connect with Mr. Adams. We will deliver a stern message to him that 1, he missed court, and 2, he's been missing you and needs to connect with you. Ms. Feely will get you those originals back. She's going to make a copy of them, get them to Mr. Adams. She may also get them to Ms. Carter, just so that Ms. Carter's got information about some of your other cases. And then you'll be a popular guy. I'm going to get you back on one of my calendars soon. It may be that one of the magistrates who hears bond motions gets you on, and then following all that, you'll have your prelim.
Excuse me, might I ask you when would I be in contact in your courtroom again? A whole nother month from now?
My courtroom?
Yes, sir.
No, before that. That's when you would be in front of the magistrate for your preliminary hearing.
Right.
When are you going to see Judge Schwall? I don't understand. That's the one that.
I'm out on bond for those cases right now.
Okay. It still lists as judicial hold, but it's set aside in June, he put everything back together.
Yes, sir.
Okay. It looks like Ms. Carter's helping you on that. Is Mr. Adams the only case he's on? Is this one?
Yes, sir.
Okay. Well, you'll want to work through that with him when you or someone associated with you catches up with him.
So you're saying, okay, my preliminary hearing is October 25th, right?
Or 4th, yeah.
Or before then, right?
I think October 24th, but yeah.
October 24th.
Yeah.
But she put in for me a bond hearing?
Yeah.
So
there's no date set, but she's filed the motion saying it's been more than 90 days. We're entitled to a bond. So when can we have our hearing?
So normally they'll get me within a couple of weeks or something?
I don't know. I don't run those calendars, but it ought to be before the prelim.
Oh, it's gonna be before the prelim.
It should be. It's not calendared that way, but it should be. If your lawyer is reaching out to the litigation managers for unindicted cases, is one where she should be saying is more than 90 days. We need to get in front of a judge. Okay. All right, I'm gonna ask the deputies to keep you up here while Ms. Feely makes copies of those things so they can get you your papers back. And then hopefully you see Mr. Adams next. We'll get you back here once we can track him down, and you may have that bond hearing in your new case. Best thing you could do is stop picking up new charges if you really want to.
I really didn't.
I know, but just I don't want to talk about it other than.
Okay, can I ask you a question? But I will be before I go back from primary.
You should be, as assuming we can get our hands on Ed Adams.
Okay.
And Your Honor, I'll be available whenever the court may need.
Excellent. You or Ms. Clark?
Yes, Your Honor.
Okay.
Is there any way you can remember Mr. Adams and let him know I need to come in?
This is F1.
All right. Well, we did one revocation. Ms. Feely, I guess just so as a placeholder, should we reset Mr. Alexander 30 days out? We can do it further and always do it sooner if Ms. Ross is successful with something. I don't want to set it so soon that you're back here saying, "Gee, I had a chance to."
Yeah, I think 30 days sounds reasonable, and I did put in the referral already.
Excellent.
And if it sweetens the pot for Mr. Peoples, tomorrow is also my birthday. I'm not turning 2.
Look at that.
Happy early birthday.
Dang, September is the month.
Oh, yeah.
All right. So what's the name of the 2-year-old?
Junior.
Junior. DP Junior.
Yeah, Dion Junior.
All right. And you need to go celebrate your birthday early tomorrow too? All right. Well, we'll put you ahead of Ms. Wood.
Thank you, Your Honor.
All right. Don't let that deter you from having lots of pleas. The other thing you could do is get Ms. Clark to step up.
Of course, Your Honor.
She was on the call, actually. After you left, she turned on her screen.
She was. Madam has us working on some indictment projects that is due today.
Yeah, I've heard about that.
So mine are finished.
All right. Good for you. Yeah, the number of indictments they're bringing back is crazy.
Yeah, we've been swamped. I was here Saturday and Sunday.
Yeah.
My wife wasn't that pleased.
Mm.
Have a great one.
So Ms. Smithman, Ms. Rivers, Ms. Tucson, we are done. Not able to do much with those revocations today, but sometimes those things happen. So thank you for being here.
To confirm, Mr. Rogers is reset and so is Alexandria Stevenson.
Yes, ma'am, that is correct.
Just making sure.
Both of them are reset, so it's only one revocation order. Tomorrow, we're going to have a whole bunch of pleas. So we'll definitely need pretrial and probation as we work through all those pleas. It'll be a fun day. Bring snacks because you'll be on Zoom for a while.
Okay.
All right. Thanks, everyone.
Okay, thank you, Your Honor.